Hi, everybody. It's me, AV. Welcome back to AV to the seventh power, another power hour. We're doing this. This is the first one we've done in a while. All of last week, I got back from Vid Summit and we had so many business meetings getting things ready for the exciting new initiatives for the channel. I'm making an app for you guys. It's going to be amazing. Got a sneak peek of it. We are creating a special app for this channel to enhance the trial watching experience. I can't wait. It's going to be fantastic. Members are going to get a special sneak peek, but today we're not here to talk about all of that. Today, we're finally, I think this is the first Karen Reed stream I've done since I had Melanie Little and Andrea Burkhart on this past summer. So I'm really excited to jump back into this. If you haven't heard, you probably heard already because it was all over the news yesterday. Mr. Michael Proctor, the lead investigator in the Karen Reed case, not only was he lost his job last year for some of the disparaging things he said about Karen Reed. It came out during trial, but he also investigated other cases, Brian Walsh being one of them. And there are other cases. We're going to dive into all of those updates, but we're also going to go down the highlight reel so you can see how confident this guy was, because literally the day of Karen's acquittal, the day of, he did an interview on 2020, right? He was very confident in him getting his job back to the point where he petitioned to get his job back. Why did he drop that petition yesterday? Why? Why did he drop that petition yesterday? We're going to find out. We're going to find out. Shout out to everybody that we have in here. Shout out to E. Capone, who was first, also sent me a Cash App this morning. Thank you so much, E. Capone. Hopefully we do get you to Cape Verde soon. He said first. Trainwreck Entertainment says second. Good morning, AV and Chatterhood. Kelly Kell says, yes, I'm ready. We're back. We're back, Kelly Kell. We're back to our good old stream. And Joy is in here as well. Tiffany says, good morning, good afternoon, my friend. Missy is in here as well. Good afternoon to you too. Andrew, good to see you, Andrew. Said it's good morning, AV in chat. Proctor be proctoring. Oh, yes. Oh, yes. Yes, he is. Maul's in here as well. That is amazing. Ron is in here as well. Danny, all the normal folks. But yes, so we've got a lot to catch up on with Proctor. There is an ASAP Borelli hearing tomorrow that we're keeping track of as well. I just heard that Trump might be shortening Diddy's sentence, and for some reason Diddy thinks he's coming home on Friday. So there is a lot for us to watch throughout the week, but let us see what is going on here. So there is a hearing that we're going to check out as well. But if you don't know who Michael Proctor is, I want to remind you real quick. So you have a face to the name, you know who this guy is. This is the 2020 interview. Very brief, it's 50 seconds, but this is who this guy is.
At what point did you develop such strong negative feelings about Karen Reed that you would say things like, hopefully she kills herself, or calling her the C word?
Those feelings developed as the case went on.
I mean, can you see how people might think, he was caught in this instance speaking about a suspect in this way. Maybe it's happened in other cases as well.
I 100% understand why people would think that.
Listen, think about that, chat. If that's the way he was talking about Karen Reed as a suspect, what about the other cases that he's investigated? Has he treated the core people in the investigation fairly in the eyes of the law? So it's so funny to look back at this in retrospect. I was looking at clips this morning and I found this one. I was just like, wow, that actually came up back in June in this 2020 interview.
But when you have, a fellow police officer around my age, 2 kids of his own, it generates an emotion. And I expressed those emotions in a negative way, which I shouldn't have. I shouldn't even, been texting my friends anything.
So that's the other thing. He was texting his friends about this. One of those friends took the stand earlier this year, right? Proctor did not take the stand in Karen Reed's second trial. But it's interesting because in retrospect, you have to think about it. Is it likely that this guy, if he did it to one, has he done it to other suspects? The answer is likely yes. So you have a work phone and you have a personal phone. What's on those phones? What is on those phones? I'm curious, chat. What is on those phones?
They are what they are. They don't define me as a person. You know, they're regrettable.
They're regrettable. Look at the face. The face of regret. The face of regret. So what's the latest that we have in this case? This dropped about probably 1 to 2 p.m. yesterday afternoon. We heard that Michael Proctor's attorney confirms that Proctor has dropped his appeal to get his job back with the state police. If you're unaware, he had been petitioning for this, and there have been a few hearings throughout the past few months that Proctor has attended to petition the state police to reinstate him and to give him his job back. Now, that was dropped yesterday, and one would think, well, why? Why would this all of a sudden get dropped? For that, we're going to go to Twitter. So yesterday, or actually this was signed on the 18th. Today's the 21st. So this was signed on the 18th, and this is Michael Proctor's signature. It says, this notice confirms the withdrawal of my appeal for the above referenced matter. I exercise my right to sign this form on my own free will. So we saw that. Now the plot thickens. The notice filed Friday in the Walsh case relates to the Miles King case, another one that Proctor worked. It doesn't say what exactly has been found on his personal phone, other than hundreds of thousands of items dating back to 2013. And the DA's office has identified discoverable materials relevant to the defendants. So what's on your personal phone? And again, that group thread, and this is why we have to go back to that cross-examination from last year so you can hear what was on the group thread. It was long, and that was just one case. So if Proctor was talking about Karen Reed in that way, was he sharing with his friends what was going on in all of the investigations that he was working on? It opens a big door. It truly does. So that being said, let's keep going. So here, 22 hours ago, Michael Proctor's withdrawal of his appeal to get his job back with the state police was signed on 10/18. That's one day after the Norfolk's DA office filed a notice of discoverable information from Proctor's personal phone in the Brian Walsh case. So you have two. You have the Brian Walsh case, and you have information that's connected to Miles King. That's 3 cases. As they previously reported, shout out to good old Ted Daniel, defendants in several murder cases Proctor worked have been seeking to learn what Proctor might have texted about their clients following his text about Karen Reed going public. So we started this stream with Proctor's confidence and how he admits that, okay, you know, my feelings for Karen Reed changed during the investigation. Here's why. But what about the other investigations? It's very interesting. So there is another document here. This was filed on Friday in the Walsh case, and it talks about the new data on Proctor's phone. Let's take a peek at each one. 4 pages here. It says Commonwealth's, share this tab instead, Commonwealth's notice for discoverable information in former Trooper Proctor's personal phone. Pursuant to orders in Commonwealth versus King and other cases, the Commonwealth began examining an extraction from a personal cell phone of Trooper Proctor for information reasonably believed to be discovered under Mass Rules of Criminal Procedure or 14b2. Due to the unexpected volume of the files discovered on the cell phone, review of the extraction is not yet complete. So his phone is in the middle of an extraction. The Commonwealth is attempting to produce information it currently believes to be discoverable by October 24th, but requires additional time to complete this review of the data extracted from that cell phone. On June 17th, Judge Doolin allowed in part for Defendant King's motion to preserve and produce Trooper Proctor's personal cell phone, ruling as to the communications, including the content, call durations, times, and numbers involved on former State Trooper Michael Proctor's personal cell phone for from the date of the charged murder to the date of the indictments. Now, it really makes you think about the other cops here as well. Is there a reason why they got rid of their phones? Higgins didn't have his phone. He threw it away at a military base and like destroyed the SIM card. And then on top of that, you do have Brian Albert, who also got rid of his phone as well. In this case, you have access to Trooper Proctor's phone. And then on the contrary, they are still fighting over Karen Reed's phone as well in unrelated, well, actually related matters, but it's just interesting because you guys know the data we can get from phones. We've brought several data experts on this channel to talk about it. Spencer being one of them. He came on during the YSL trial and in the middle of the Karen Reed trial as well. So we could talk about data forensics and the type of things that you can get and extract from it. That being said, let us take a peek at the next page of this document. Let us turn the page. Here we go. What was the sentence? How does it start? The Commonwealth shall promptly produce any other data from Proctor's personal cell phone that constitutes investigative materials or is favorable to the defense within the meaning of Mass Rules of Criminal Procedure, Rule 14. Judge Doolin further ordered that the Commonwealth may move for appropriate protective orders for the judge's prior review to producing information that the defense counsel shall not show or provide the communications produced pursuant to this order to anyone else except the defense counsel may show, but not given them to the defendants in this case. Upon filing a motion and amended motion for clarification by Proctor's counsel on August 13th, Judge Krupp clarified that the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range, and that Proctor had a legitimate interest in protecting attorney-client or spousal communications. Judge Krupp ordered that by certain dates, looks like 4 things. Proctor has to provide his phone to the Commonwealth. 2, the Commonwealth extract a full digital copy of the phone, so make a clone of it. Then provide a copy of that to Proctor's counsel for privilege determination and return the cell phone. 3, counsel provide a privilege log to the Commonwealth. And 4, the Commonwealth shall search the cell phone extraction with the exception of the common communications identified in Proctor's privilege log to locate the information authorized by the initial order. So it looks like it was a 4-step process. The first thing that Proctor had to do was give them the cell phone. The second thing is a full copy or clone of that phone needed to happen. The third step is that Proctor's lawyer would take a look at what's known as a privilege log, because there's some information that should not be released, right? Or if it's unrelated to the case, it's a personal phone. There's so many things on this thing that we use every day. Some information is relevant, some of it is not. But just the pieces of data that we use every single day, whether it's maps, whether it's the app usage that you have. We saw that in the Karen Reed case with health data when it came to Officer O'Keefe, things of the like, right? So there's some information that needs to be reviewed, and that takes time. So once Proctor's attorney creates this privilege log, the next step would be the cell phone extraction with the exceptions that are on the privilege log that Proctor's attorney had filled out. So it looks like that needs to be done by the 24th. Next up, it tells us that by the 24th, the Commonwealth must produce Defendant King and others a copy of the privilege log and all documents required to be produced in the initial order as clarified herein, except those documents identified on Proctor's privilege log. The Commonwealth proffers that it has received Proctor's cell phone and that an extraction has occurred, that the phone was returned to Proctor, and that Proctor's counsel provided, and let me turn the page to page 3, and we'll go from there. Here's page 3. Let us keep reading. The document entitled Privilege Log on the court-ordered due date of September 26th. The extraction has yielded hundreds of thousands of items, some of which are dated as far back as 2013. The volume of items was unexpectedly larger than the representations of Proctor's counsel regarding the cell phone. Review of the extraction is underway, and the Commonwealth has identified materials that it reasonably believes to be discoverable under 14b2. In the King matter, and in other cases where Proctor was a witness, in the matter of the grand jury investigation, disclosure of exculpatory information arising from unrelated grand jury proceeding, part of the prosecutor's official duties, and they may be disclosed without the order of the court unless prosecutor seeks protective order limiting disclosure. In addition, where appropriate and consistent with the Commonwealth's obligations, the Commonwealth will produce pertinent information to individual law enforcement agencies. The Commonwealth further proffers that it reasonably believes it will be able to do and is making efforts to that end to produce information deemed to be discoverable in the text chats and video audio files from the extraction of Proctor's personal cell phone by the 24th, so in 3 days. However, the Commonwealth is requesting additional time to comply with the order in King and other cases to review other files on the extraction from Proctor's cell phone. Okay, let us bring it to the last page. Open here. The Commonwealth anticipates continuing a review and providing those materials to the defense in this case as soon as practical, but after October 24th. The other thing here is it's, and shout out to Kelly Kell, she is like the best. Updates us to let us know that Proctor's lawyer said he got a new phone and that they weren't going to pull anything from before 2024. And all his texts are now on a 30-day delete. Wow, 30-day delete. I wonder why. But surprise, it pulled up texts and data going back to 2013. So Proctor's in trouble here. How would you have your text on an auto delete for 30 days, every 30 days since you got a new phone, but the extraction dating back to 2013 shows that you can try to run, but you can't hide anymore. What are you hiding? What are you hiding? So that is the latest from Twitter as far as the documents when it comes to this case. A lot of people are talking about this because we are soon going to find out what has been on Michael Proctor's phone. And of course, AJ Alan Jackson, the other big thing that Ted Daniel reports is that we have a statement from Alan Jackson, which reads, Michael Proctor's sudden withdrawal of his appeal wasn't an act of humility. It was self-preservation. He learned investigators have recovered the text messages from his private phone dating back years, and he wanted no part of what those text messages would reveal. He didn't accept accountability. It hunted him down. And as Noble has admitted, the years-long corruption is systematic. So again, he's running, but he can't hide. The 30-day auto delete is pretty strange. Now, there was a hearing on this. It looks like it was live streamed yesterday. So let's take a peek and see what happened. I did skip ahead, so, because we were waiting for the feed to start. It's about 30 minutes long, so we'll check that out, and then we'll go to what exactly happened in Karen Reed's case when it came to Michael Proctor on the stand and when he was confronted about those text messages, because the statement that we just read from AJ is now going to make more sense for those that are new. But let's take a look at this hearing. I did not get a chance to see it. The court was very empty. But let's.
Guys, you just keep this back. All right.
So before it's now in session, you may be seated.
We're going to start with number 12, Hummel versus Kevin Moore, 24 CR 214. Mr. Moore is not present. His presence was waived by his attorney, Scott Murphy. The Commonwealth is represented by Assistant District Attorney William O'Driscoll. The matter is on for status. If the parties could please identify themselves for the record.
Your Honor, William O'Driscoll, we have Commonwealth.
Okay. Good afternoon, Scott Murphy for Mr. Moore.
All right. What are we doing today?
So I received about 12:30 today a motion for a buccal swab along with the DNA report that we've been waiting for quite some time. I just need a brief time to file my opposition, and we're going to have a hearing on that. I think we talked about November 3rd was the date the court was available, and we're available.
Great.
So I'll file my opposition. I can file by the end of the week.
We'll bring your client in for that date.
Yes,
if a buccal swab is allowed, be done on that date.
Thank you.
Okay?
So as Mr. Moore, it's continued to November 3rd at 2 p.m. for hearing the Commonwealth's motion for DNA. Thank you.
Thank you.
Is Ms. Yaz still here? We have 88.
She's in the back.
She is? Okay. This is number 11, Commonwealth versus Tristan Smizer, 23 CR 159. Are we ready on Mr. Smizer, or do you want a second call? No. Okay. Mr. Smizer is not present.
And real quick, guys, I haven't parsed through this, but it looks like they have the court proceedings for everyone for that day. So it wasn't just this case that was called, it was a few others. So I'll give it a few more minutes and then we'll skip through to what we need to see.
Your Honor, good afternoon.
Good afternoon.
Bethany Rogers on behalf of Mr. Smizer. He just sent me a message and I was just replying to him about court today. So
Okay. He's on his way. Should we wait?
No, he's here.
Okay, great.
Perfect.
Mr. Smizer, come on in. Your timing is impeccable. Okay, what are we doing today, Ms. Yaz?
Your Honor, you had set today as a date for the Commonwealth to file a certificate of compliance,
Great.
which I have.
Okay.
You had also set today for the Commonwealth to file a motion for reciprocal discovery, which I am.
Okay.
I am also filing a notice of discovery 6 and a notice of intention to introduce medical records.
Sure.
And for those asking about the Little Dirk video, that was actually supposed to be today's subject. We do have something that's in the middle of production. I recorded it on Sunday and the editor's working on it now. So because of the Proctor thing, that should be coming out tomorrow for those that are waiting on it. All right, let me skip through this.
Which I have most of that done. I sent out, I sent out the summonses, and with the summonses, I sent out specific requests to both the lab and the police officers for them to answer our specific questions. I've already checked with our office and to see if there was any information that
30 days from now, sometime.
Thank you. Are we ready on? Thank you. Next before the court numbers 5, 7, 8, 9.
Okay, here we go.
10.
I think we're in the right
Number
spot.
5 is Commonwealth versus Miles King, 21 CR 320. Mr. King, was he brought in today?
He was not.
Okay, his presence was waived today. Oh, his attorney Scapiccio could not be here, but I believe attorney Krowski is.
Okay, so this is the Miles King case. This is the other case that Proctor worked. So we're going to hear what they talked about yesterday during this hearing, a little bit more about Proctor's phone, and then we'll move towards that cross from last year.
Attorney Scapiccio on behalf of Mr. King.
Okay, I'm like calling, people are coming down. Okay, also before the court number 7, Commonwealth versus Bianca Ciancio, 22 CR 264. Ms. Ciancio is not, her presence was waived. Her attorney, Joseph Cataldo, is present on Zoom. Also before the court number 8, Commonwealth versus Giovanni De Los Santos, 22 CR 267. He is not present. His presence was waived by his attorney, Joseph Krowski Jr. And also before the court number 9, Commonwealth versus Sean Johnson, 22 CR 268. Attorney Krowski is standing in for Attorney Scapiccio. Mr. Johnson's presence was waived. And finally, before the court, Commonwealth versus Brian Walsh, number 10, 23 CR 91. Mr. Walsh's presence was waived. Attorney Larry Tipton is present. The Commonwealth is represented by Assistant District Attorney Lisa Beatty. If the parties could please identify themselves for the record.
Good afternoon, Lisa Beatty for the Commonwealth, and there are various other assistant district attorneys representing the trial teams present.
All right.
Judge, good afternoon. Attorney Kurowski again, as mentioned, standing in for Attorney Scapiccio on behalf of Mr. King, and standing in for Attorney Scapiccio on behalf of Mr. Johnson, and representing Mr. De Los Santos.
Thank you.
Larry Tipton for Mr. Walsh.
All right. And Mr. Cataldo?
Yes, good afternoon, Joseph Patello on behalf of Bianca Cancio.
Okay, we can hear you loud and clear, but we cannot see you.
I will, Madam Clerk, if I just log on, I'll come back in because it says my camera is working. And
No. It's all right. Just so long as you're content, we're content.
All right. Yes.
Okay. What is the current status?
Your Honor, Judge Casper issued an order on Friday which allows the Commonwealth to provide to the defendants who in the cases that were called, in addition to some other designated defendants. The order allows the Commonwealth to produce some grand jury materials to the defendants in those cases, provided that they are filed under seal. The order that was issued on Friday, we are also allowed to produce to the parties in the court as long as it's filed under seal, and an index, again, as long as it's filed under seal. So I have those materials present for the people who are here today, and logistics are making this a little bit complicated for people who aren't present. But we have some signed motions for protective orders and a draft order for this court. And assuming that the court endorses the draft order, then the attorneys can start signing the acknowledgement, which is at the bottom of the draft order, and the materials can be produced.
There's a draft order for this court to consider?
Yes. So I don't know. This is a signed one on Walsh. They're all identical at this point in time.
All right, let me take a look.
It is so strange to not see Bev on the stand, but it's refreshing. Of course, this is a drama-free zone. I keep it clean for y'all. Oh, we're about to flashback and look at that cross again. So we will see Bev on the stand. The judge is taking a minute to read. Come on, come on.
I also have a copy of the index and the order of Judge Casper if you want to review those on this time.
Okay, I have seen that. This only covers certain grand jury material. It does not include or reference the TUI materials, right?
The way that the process worked was that both items were considered grand jury materials because one was an exhibit in the grand jury. So they are both grand jury materials, as I understand it, based on. Is it now? I want to make sure that is the index also.
Yeah, the index is also referenced in. Let me just see for a second. In your proposed motion, protective order.
So there is no separate TUI materials.
my gosh. This hearing, it's so crazy. Let's look at this. Embattled Karen Reed investigator ex-trooper Proctor ends the fight to get his job back. This is as of this morning from Channel 5. Let's take a look at what they're saying.
It was a surprise move, and some suggest it has a lot to do with what was found on his phone.
With this letter over the weekend, former state trooper Michael Prctor abruptly dropped his bid to get his job back. He was fired after crude and offensive texts he wrote about Karen Reed surfaced during her first murder trial.
She's a whack job. Yes, she's a babe. Weird Fall River accent, though.
That trial ended in a hung jury, and Reed was acquitted of the most serious charges in the second trial in the death of her boyfriend, Boston police officer John O'Keefe. Now, other cases Proctor investigated have drawn scrutiny.
There has been a trend, not just in Massachusetts, but in other states, to make alleged misconduct, potential misconduct on unrelated matters, not only discoverable, but also admissible in trials that touched other defendants.
Joseph Krowski represents defendants in other cases Proctor investigated and says key rulings could help his clients.
He's looking security heavy. Proctor put on weight.
Implication, of course, is there is information in that material that is exculpatory or potentially exculpatory to the defendants.
The union that represented Proctor suggests his cell phone is at the center of his latest move, saying, following the discovery of new evidence from Michael Proctor's cell phone, the State Police Association of Massachusetts Executive Board unanimously voted to sever all support for his appeal.
Oh. Okay, I didn't know that part. I just thought he decided to withdraw. The state police are no longer supporting it. What?
We hope this decisive move closes a deeply embarrassing chapter in state police history.
At least they're admitting it. At least they are admitting it. The fact that it is embarrassing for the state police. They're like, no. So this was not a Proctor thing. This is them saying, hey, that phone evidence, we're no longer supporting you. So this is interesting. This came out this morning at 8:53, guys.
An attorney who represents Karen Reed says Proctor's move is an act of self-preservation, saying he learned investigators had recovered text messages from his private phone dating back years, and he wanted no part of what those messages would reveal. He didn't accept accountability. It hunted him down.
Now, we have reached out to Proctor and his attorney, but they're not commenting on these latest developments. We're live in Dedham tonight. John Atwater, WCVB News Center 5.
So that had to be yesterday. So he had to report on that yesterday because it was raining yesterday, right?
Of the 1 in 10.
All right, we don't want to see all of that. Let's refresh here. But, you know, that is the video that came with this article. It basically says former Massachusetts State Police Trooper Michael Proctor fired over misconduct allegations, has withdrawn his appeal to get his job back before the hearings were set to resume this week. Members of the Massachusetts Civil Service Commission were expected to resume today in Proctor's appeal, which began in August. This notice confirms the withdrawal of my appeal, and that was signed on Friday. Now that Proctor has withdrawn his appeal, the next step will be that the commission issues an order of dismissal based on the withdrawal. So the news has reached out to Proctor and his attorney for comment, but they didn't have a comment. Following the discovery of new evidence from Michael Proctor's cell phone, the State Police Association of Massachusetts Executive Board unanimously voted to sever all support for his appeal. All of it. We hope this decisive move closes a deeply embarrassing chapter in state police history. In June, the jury in the retrial found Reed not guilty of second-degree murder, but guilty of a lesser charge of drunken driving in the death of her boyfriend, John O'Keefe, who was a Boston police officer. Her first trial ended with a hung jury. The prosecution argued that Reed hit O'Keefe with her car outside of the home in Canton during the snowstorm following a night of drinking. Reed's attorneys and someone else was responsible for killing John O'Keefe, and Reed is the victim of the law enforcement cover-up. In March, the three-member trial board found Proctor guilty of violating 4 department policies, including sending insulting text messages about Reed, sharing sensitive information about Reed's case with people from outside law enforcement. That's probably what is on the phone. creating an image of being biased against Reed, and drinking while on duty in connection with an unrelated cold case. So you guys can see why these defendants want this access to his phone. In August, Proctor's lawyer, Moynihan, argued that the investigation of Proctor was rushed under political pressure, and that there was no evidence that his client's personal feelings about Reed influenced the case or violated policy. Moynihan stated the state police have no policy that prevents investigators from sharing personal feelings on personal cell phones. Wow, that's the argument. State police have no policy that prevents investigators from sharing personal feelings on personal cell phones. How about don't talk about the damn case with your friends? Don't do it. Why are you even doing it? I can't with this. But Massachusetts State Police Attorney Stephen Carley said the conduct rules apply at all times. So that's already a contradiction. Proctor's lawyer versus the Massachusetts State Police Attorney. So Moynihan and Carley here. Carley says the conduct rules still apply. So the state police, they're done. They have excommunicated him, right? Personal feelings on personal cell phones. There's no rule that says I can't do that. Carley is saying that the conduct rules still apply. It doesn't matter if it occurs by email or smoke signal. During August hearings, Carley played a video from Reed's first trial showing Proctor reading the text messages to a friend in which he said he thought at one point that O'Keefe might have been beaten and that Reed waffled him with a vehicle. Carley said Proctor consumed alcohol and then operated his cruiser while on duty, released confidential information to individuals outside of law enforcement, and called the suspect and eventual defendant, Karen Reed, a babe and a nutbag. Moynihan said Proctor's personal feelings about Reed did not impact the integrity of the investigation or the outcome against Reed. That's such bullshit. Michael Proctor did not commit a crime. Yes, he did. How is it that Karen Reed can be found? Karen Reed can be found guilty of driving while drunk, but Michael Proctor can't. Make that make sense. He did not commit a crime. Yes, he did. Michael Proctor did not violate a specific policy prohibiting personal conduct on a personal phone because there is no specific policy. These are two very important facts to remember in this case. Oh my God. In his now withdrawn written appeal, Proctor said he was never disciplined prior to this case and that all messages in question were sent on a personal phone while he was off duty and with an expectation of his right to privacy. Ultimately, Proctor said that he was treated, like what they all say, unfairly. During Reed's first trial, Proctor was questioned about messages he had shared with a group of friends. After reading one of those messages in which he called Reed a whack job and an expletive, he apologized to the jury for his unprofessional conduct. That's okay. Court of public opinion. We don't forgive him. In another text message, Proctor told his sister that he hoped Reed would kill herself. Proctor described his messages as very regrettable. Proctor was suspended and later terminated in the wake of Reed's first trial, which ended with a hung jury. Reed was ultimately found not guilty of murder with the death of John O'Keefe in the second trial, but was convicted of an OUI. Proctor has denied planting evidence during the investigation, and his family said they faced harassment as a result of the high-profile case. Had to break up that, this very dry hearing here with some new news, right? So that was an article that was released this morning. I think it's Channel 5. That was at about 3 hours ago. So that's the latest on this case as of today. But I'm just going to skip through this hearing and we can go back to what Proctor actually said.
In connection with the Reed case is now going to be turned over.
No.
Well, so that's my question.
Okay, I'm sorry, I didn't understand your question. I think, are you referring to the mention of TUI materials?
I am.
Okay, that was what was produced to the parties in Reed.
Okay.
So that is referred to as TUI materials for the purposes of what was produced to both the Commonwealth and the defense in Reed.
Right.
So this is a subset of those materials.
And the question is whether the obligation on the Commonwealth to review materials beyond what is contained in the order from Judge Casper is separately determined by the U.S. Attorney's Office regarding TUI materials. That is to say, the universe of confidential materials that we've been talking about for months.
Yes.
Okay? Is it all now going to be able to be reviewed by the Commonwealth and turned over to Defense Counsel, or only some subset covered by this order by Judge Casper?
We've already reviewed all the materials, and we had done that prior to the last court date before then.
Right.
We are only permitted to provide to Defense Counsel certain materials. These are the only materials that we sought permission after our review to provide. That is to say, the other materials, we did not believe met our obligations under Rule 14.
So you reviewed all the confidential information, and the only materials that you felt needed to be turned over were the two categories of information contained in Judge Casper's order. All the rest, you did not seek authorization either through the U.S. Attorney's Office pursuant to TUI or from Judge Casper to turn over.
That is correct.
Okay. All right. And, okay. I'll hear from the parties, the Defense Counsel, if they wish to address the court.
All right, let's hear it.
So I guess I'll start, Attorney Krosky, on behalf of Mr. De Los Santos. My understanding of the order was that under the umbrella of grand jury, we are going to receive these materials, which would include all of the grand jury from the federal court, including any and all exhibits related to Trooper Proctor. It is my understanding, though, that there are additional...
There may have been more than one exhibit. It seems
right.
like you only get one exhibit.
There are materials outside of what actually was presented in federal court that we are also going to have access to, and that would be information from the cloud and the personal cell phone of Trooper Proctor, if I'm understanding that correctly.
So I want to make sure that I'm answering the question that's being asked, but separate from the motions regarding what was produced to both the defense and the Commonwealth pursuant to the TUI request. In King and Johnson et al., Judge Doolin had issued an order for Trooper Proctor's personal cell phone, the device, not the cloud, the device. And you modified that order. And we have been in the process of executing that order. And that is an entirely separate process from this.
Right.
Right, that's what I was saying. I just wanted to be clear on the record that this is not...
This is why Trooper Proctor is screwed. And this is what Kelly Kell was talking about earlier. You have Trooper Proctor's actual phone, which is being cloned, right? But here's the thing. They got him on the cloud. That's where I think this is coming from. There's a phone extraction itself, but there's also cloud extraction.
On
that
these
iCloud.
cases and these defendants, this is not the end of the issue as it relates to discovery related to Trooper Proctor.
Right, but I want to be clear about what this does and doesn't do, right? The Commonwealth has done its review on all the confidential information that was obtained from the federal court, has made a determination that what needs to be produced is certain things, and as I understand it, the only things that are authorized to be turned over by Judge Casper are those things that the Commonwealth has already predetermined are the things that need to be turned over to Defense Counsel in this case because they constitute exculpatory evidence. But they have reviewed other things
Yes.
and made a determination that those other things do not have to be turned over, are not exculpatory in any manner in which exculpatory has been construed. And so it seems like the Commonwealth has discharged its obligation, has been authorized to discharge its obligation to review this information, the confidential information obtained from the feds, and has gotten the authorization to turn over the stuff they think needs to be turned over.
May I add two things?
Sure.
We also, because we want to be clear, as clear as we can be and as clear as the federal government will allow us to be. We sought permission to have the index, which I think is something that was discussed in hearings previously. So we also will have the index, which gives some idea of materials that we did not seek authorization to provide and do not have authorization to provide and are not providing. And then...
and that's the index of other materials.
Correct.
Okay? And that will, between the stuff that is authorized to be produced and will be produced, subject to a protective order, and the index, the defense will know all of the stuff that you reviewed.
And
is that right?
That's correct. That's the intention, is so that there's not a big mystery about what the other materials were. And in addition, and why those, as outlined in the U.S. Attorney's Office letter, why those other items are not Rule 14 material in these cases.
I'm sorry, the index indicates why they are not Rule 14?
It provides, the index itself doesn't provide that, but reading the index, I think, provides some information about why they're not Rule 14 material.
Okay.
And then finally, the order now contemplates or orders a return or destroy date of the other materials of October 31st.
I do have some concerns, obviously, in thinking about a reservation of rights on behalf of the defendants, because we're in this unique position here where the government is really the arbiter of what is or what is not Rule 14 exculpatory information. My concern is once we start getting into the actual discovery, it might become obvious to us that other information is out there that is not discovery. It's a very difficult thing from the position of a prosecutor to make a determination, not knowing the defendants and the defendant's theory of the case, what is or is not exculpatory. So I am concerned with these, quote, other materials being destroyed on October 31st, and I think there should be something put in place where we can at least have those documents set aside, not subject yet to any type of disclosure, but set aside for a potential future review.
So, Your Honor, this return or destroy provision, and I just want to make it clear that it is the intention of the District Attorney's Office to comply with the federal court order. We will be returning a set of documents and destroying all extra documents. So the defendants have had the ability to make TUI requests, to seek to intervene, and have not. We are confident that we have met our Rule 14 obligations, and I would tell the court, and the other assistant district attorneys who participated would tell the court if they were not confident. And again, I think the index will be helpful, and I'm able to provide that index today.
Okay, I think what I will do is, in an abundance of caution, and against my better judgment, because I really don't want to have another hearing on this, but I will schedule a time to see anybody who wants to be heard on the issue of the other list sometime next week, after you folks have seen it and have had a week with it, to consider whether you think there's anything that you need to bring to the prosecutor's attention about the things that might be on that other list. You obviously don't have the other list, so you shoot blind right now.
Wow.
But you'll have it today, and you'll be able to come to some sort of conclusion as to whether you think, given the information on that list, you have some reason to believe that it would contain exculpatory information, based on the chronologies in your case or whatever else it is.
Step back to get my phone.
Sure.
Okay, so we have an update on that. This was yesterday's hearing.
Okay.
I am back here on October 30th. I don't know if that's a good date for the parties. I don't know.
Well, it's certainly a good date for me. I can accommodate you on the 30th, but it's a little bit close to the destroy or return date, I would think.
I can't speak for Attorney Scapiccio. It's really the only date next week I can do. I'm out of state in federal court at the beginning of the week. At least it gets me in here to preserve.
I'm happy to see you on the 30th. How does the 30th seem? Okay, Mr. Cataldo?
If I can't do it, one of my colleagues would be able to stand in for me, so yes.
Okay.
We can do the 30th.
How does that look for you, Attorney Beatty? Okay.
And if we could just approach.
Okay. 30th at 2.
Am I issuing names for anyone or leave your presence?
Could we
On behalf of,
have the position be issued?
Go ahead, Mr. Cataldo.
On behalf of Bianca Ciancio, I'm after that her appearance be waived on the 30th.
All right, we will waive her appearance.
Thank you.
All right, they're approaching.
All defendants' presence waived?
Yes. Yes.
Okay. All defendants' presence will be waived for the hearing on the 30th.
And Your Honor, there are a couple of other cases that we just need to finish the paperwork on. Can we do that administratively for the motion for the protective order and the court order?
Yeah, get them to us, and we'll make sure we get them approved. I've got 2 here. Let's see.
And then if we could have the orders that you've endorsed back just for now so that I can have the attorneys acknowledge them, and then we will bring them back to the clerk.
Okay. Mr. Krosky, this has been signed by Ms. Capiccio? Are you signed it on her behalf?
With her authorization.
Okay.
And we'll do so for the King one as well.
Okay.
All right, Judge, come on.
I'm sure I'll get another 13 of them or something like that. Yep, to sign. Okay?
Your Honor, do you want a copy of the index? Or do you want to wait?
I'll wait to see if I need to see a copy of the index.
Thank you.
Okay?
If you would have just put those on the desk downstairs.
And anybody who wants to file something in advance of the 30th, if you feel like you need to, you're welcome to. I'll look at it beforehand.
Thank you.
Okay?
So the matters are all continued to October 30th at 2 p.m. for status. Defendant's presence is waived, and we'll see you then.
Just a brief sidebar, please.
Sure.
Yes.
All right, so I think that concludes the hearing when it comes to terrible audio. Is that the mute button?
Mr. Samuels is present and represented by attorney Michael Rusconi.
Okay, so that concludes the hearing that took place yesterday. Again, Michael Proctor and the damn phone. We're going to find out what's on it. I know we will. Whether it's this one, the Birchmore case, if it's the King case, if it's the Walsh case, all of it is connected because Michael Proctor has his hands on these cases. But for him to withdraw, when I read that headline initially, I thought that he did it through his own volition. It was unrelated to anything else, but it also didn't make sense. Like, okay, if you were this confident and released a 2020 interview, right? Literally the minute she got acquitted, that 2020 interview went up that night, and he was so confident in everything that he was saying and that he didn't do anything wrong. And, he apologized for what he said. We're actually going to take a peek at what he said, just so people are reminded of who this guy is, what he said about this woman, not even a male defendant. And it shouldn't matter gender-wise. But like, if you're talking to your friends about an active investigation, that's a huge problem. That's why you see these defense attorneys working these other cases that Michael Proctor has his fingerprint on. That is exactly why they want access to his phone. What did you say? And with this 30-day thing where you're clearing out your phone, but you didn't realize that it doesn't clear out on the cloud, Michael. That's a problem. It doesn't clear out on the cloud. So we're going to be able to see what's going on. Real quick before we jump into a blast from the past, seeing AJ cross-examine Michael Proctor, I do want to just grab a few super chats. And again, all the ways you can support the show are below. Thank you again to E. Capone, who sent me a Cash App this morning. Shout out to D with the 2, says Trooper Prostate. My bad. I mean Proctor. Oh, D is coming out swinging. Hits me with another one. Says Proctor's MO being revealed, talking and texting. Yeah, that's what it is. This is not high school. You shouldn't be gossiping about an active investigation. It's not fair. in the eyes of justice? Does a defendant have a fair shot if you're doing that? And you're the police. You're the police drinking and driving, like, and you're trying to put Karen down for that. For drinking and driving, you were doing the same thing. All the disparaging things you're about to hear in this reminder. He did the same thing. He was drinking and driving, right? Shout out to Senator with the 10, says AV, shout out from your fellow Libra. And today is my birthday, chat. Let's be nice. Let's wish Senator a happy birthday. He has been in my community for years. And, you know, I hope you have a great day, Senator. You're enjoying it. I'm trying to get more active on these power hours. There's just so much going on post Vid Summit. You guys would not believe the amount of like meetings I had last week. Like I'm meeting with the app developers. Hopefully we'll have our app ready by January. So from now on, all major cases that I cover are going to be behind that app, and it's going to be exclusive content. We're really excited. We got a full team working on that. So we have that. I am probably leaving StreamYard. I love StreamYard, but Ecamm is looking very good as far as production value. And if you guys remember with the Karen Reed case, I talked to the Ecamm team because we had like 2 outages with like 3,000 people in the chat. I'm like, oh my God, we need to fix this. So we're moving to Ecamm. I might do a few members only tests with you guys just to make sure that we like the platform, all that stuff. Who else did I meet with? YouTube partner manager, Opus Clips. So we're now going to start clipping while we're live. So if you guys are busy and you miss it, or if you miss what's happening in the live proceedings, we'll be able to clip while I'm live, and my team will be able to get that out for you. What else is on my board over here? Yeah, and then a few other brand stuff. It's so busy. In production, we do have Lil Durk. I am looking into this Diddy story, but the White House is saying, guys, the White House officials are pushing back on a report that Trump is considering pardoning Diddy. I did do the Diddy sentencing hearing here on this channel, but it seems like that is fake news. So the White House is saying that they don't plan on giving him a pardon. I know that there are rumors about like shortening his sentence. Diddy thinks he's coming home on Friday. I don't know. I got my eye on it, but we'll see what happens there. Tomorrow we have ASAP Borelli with a hearing to see if that case is going to continue in January. And again, Dirk is continuing Thursday. I'm going to jump into Courtney Clenny. We're going to look at some of her. We're going to look at some of the footage because her case is starting December 1st. And then, of course, I'm going to keep track of this Karen Reed thing because the options are right now. If Karen wants to add all of the people that were in the house, it's going to take a little bit longer. If she decides not to add the people in the house, then we can get started with the civil trial as early as March. That's what the judge mentioned in the hearing. I think it was like 2 weeks ago at this point. So Karen's civil trial is on the docket. We just don't know when until we have a ruling on that one. So there's a lot going on in the legal space, but that is just where we are. I'm also keeping track of the Letitia James thing. You know, she was it indicted last week for fraudulent records when it comes to her mortgage. So we're researching that one. And then Fonnie Willis has a hearing on November 17th. I don't know how I'm doing this all off the top of my head, but you can see Q4 of this year is very busy in the legal news space. But because I'm Boston born and raised, I really do want to keep an eye on what's happening with Karen Reed as it happens. But thank you so much, Senator. Enjoy your birthday. So many people are giving you birthday love. Thank you, Tiffany. Thank you to SS3 Pisces. Jake Hellman says happy birthday. It's Nini's birthday too. Happy birthday, Nini. And to Senator. Love the folks in my chat. I hope you guys are having wonderful days and enjoying your birthdays and have some plans. Shout out to D again with the 2, says, I guess radio silence isn't taught anymore. Could be. Could be. All right, let's get to this debauchery. Do y'all remember this? Blast from the past. AJ chews him apart on the stand. It's one of my favorite cross-examination moments from both Karen Reed trials, and AJ just did phenomenal here. Let's take a peek and let's go back in time.
Turn to tab 2 in the binder in front of you. Can you take a look at the face page of what's under tab 2 and tell me if you recognize that?
Yes, sir. It's a private text thread with high school friends.
And this includes 9 participants, 9 chat participants that you
9
engaged
people.
with?
That's correct.
9.
Those participants include people by the name of Bird, Whitey, and Doc, correct?
Correct.
Think about that. 9 people on one case. What is the likelihood that he's talked to those 9 people about other cases? It's very likely.
And then there's some other folks in there. They're identified by at least the last 4 digits of their phone number, correct?
Yes.
So this is a group text or a group chat with you and 8 of your high school friends about this investigation, correct?
Yes.
Trooper Proctor, you never thought when you were engaged with these other 8 individuals that this particular set of chats would ever become public, did you?
No, I do not.
I want to take a look at page 2527, if you could turn, that's on the bottom right of the document in tab 2. Do you recognize, do you have that page in front of you?
Yes, sir.
You recognize that this group chat was taking place on January 29th at about 10:52 p.m., correct?
Correct.
And the person that I'll identify as 5051, that's the last 4 digits of that phone number, indicates Chip, name of that BPD cop, correct?
Correct.
First of all, you indicated on Monday that you're Chip, is that right?
Yes, sir.
You responded at 10:53 p.m., John O'Keefe, is that right?
Yes, sir.
So you were willing to tell, just a few hours into an investigation of the death of a Boston police officer, you were willing to tell a bunch of high school buddies details about the investigation, including the name of the victim, correct?
At this point, it's 16 hours later, sir. Not a few.
16 is a few hours, correct? I'm not talking about days later.
Think about this in retrospect. 16 hours into an investigation, you're talking to your freaking high school friends and you're telling them about the investigation. 16 hours in. He goes, oh, no, that wasn't a few hours. Yes, it was. Yeah. Are we looking at the same thing, Proctor?
It was about 16 hours later, sir.
Correct. And you identified John O'Keefe as the Boston police officer who is fallen in the yard at 34 Fairview, correct?
Correct.
You also informed, if you will skip to page 2529, you also informed these same folks, these same high school buddies that, quote, all the powers that be want answers ASAP, correct?
Yes.
You knew, Trooper Proctor, that there was brass that wanted this case wrapped up quickly and efficiently. Isn't that right?
Objection.
I'll allow that. Is that what you were thinking?
No, the people wanted answers, sir.
They didn't just want answers. They wanted answers ASAP. What does ASAP mean?
That's as soon as possible.
Right. And you were texting this to your high school friends, again, 16 hours into this investigation, right?
Correct.
And you knew at that time, Trooper Proctor, that this was not going to implicate in any way, shape, form, or fashion another cop, correct?
Correct.
In this text exchange, let's turn to 2532, actually. Do you have that in front of you?
I do.
In this text exchange at 10:56 p.m., your buddy Bird writes, I'm sure the owners of the house will receive some shit, correct?
Correct.
How did you take that to mean? Did you take that to mean that he could get in trouble?
Yeah, I'm not sure exactly what my friend was getting at.
Well, you had some idea.
Yeah, maybe.
Said the owners of the house isn't going to get any shit for this, right?
That's how I interpreted it.
Yeah, you interpreted it like he's not going to get in any trouble. He's not going to be a suspect, correct?
Correct.
And he's not going to be implicated in any way. Is that right?
Correct.
And your answer was one word, correct?
Yes.
What was that word?
Nope.
And then you followed that up with an explanation as to why you said no, didn't you?
That wasn't the explanation why I said nope. I simply said, Homeowner was a Boston cop too, meaning Mr. O'Keefe was a Boston cop. The homeowner was a Boston cop as well.
The question that preceded your answer, nope, the homeowner's a Boston cop too, was the homeowner's going to get some shit for this, correct?
That's not what I meant with that text.
That's what you wrote.
Not what I meant, sir.
All right, let's take it in order.
This was that night. This is the 29th at 10 p.m.
Question. Oh goodness, the homeowner's going to get some shit for this. Answer, nope. Next text, he's a Boston cop too. That doesn't sound like an explanation for your nope.
No, that's just saying he's a Boston cop as well. Mr. O'Keefe is a Boston cop.
And that's why he's not going to get any shit. Correct, Trooper Proctor?
Well, he's not going to receive any shit, sir, because Mr. Albert, the homeowner, had nothing to do with Mr. O'Keefe's death.
And you knew this 16 hours
whatever.
into your investigation.
Yes.
Less than a day.
Yes.
To your satisfaction.
Wow.
To my satisfaction and
you
to the
hadn't
members
been
of my
to the
unit.
crime scene?
So let him finish. We didn't get the finish your answer.
To my satisfaction and to all the members of my unit who investigated that day.
Objection. Calls for speculation.
So I'm going to let it stand. Trooper Proctor, you have to keep your voice up, okay? Jurors need to hear you way back there.
Yes, ma'am.
The fact of the matter is, you hadn't been to the crime scene by the time you wrote this text, correct?
Correct.
You hadn't been inside the home, correct?
No.
You had you had questioned a grand total of 3 percipient witnesses at this point, correct?
Yes.
And 2 of the 3 were named McCabe, right?
Correct.
And 1 of the 3 was named Albert, correct?
Yes.
And it's against that backdrop that you wrote, nope, the homeowner's not going to get any shit because he's a cop, right?
That's not what I meant by that.
At 10:57, Bird goes on to write, he, the homeowner, must have been a puddle to accomplish that. And then he writes, who's the homeowner? And then he writes, I hope not, but I can see it. Correct?
Yes.
A puddle means drunk, correct?
That's a term for it, yes.
In other words, Bird wrote that the homeowner must have been so drunk, so wasted to have killed him. Correct?
Objection.
Do you know what that means? Do you know what that text means?
Just the puddle part, Your Honor. That term.
All right, so he can answer that.
And the puddle part means drunk or wasted, right?
Yes.
And what Bird actually wrote was, he must have been a puddle to accomplish that. Correct?
That's what he wrote.
And then you write back, quote, she waffled him. I looked at his body at the hospital, right?
Correct.
You used the phrase waffled about a Boston police officer who had fallen in the snow and died in someone's yard. And you decided to use the word waffled him, correct?
Objection.
So sustained. Ask it differently, Mr. Jackson.
Of course, I'm muted. I always do that. So at the start of the stream, we saw the 2020 interview, or at least a snippet of it, where Proctor was like, oh, yeah, I identify with the Boston cop. I identify with John O'Keefe. You know, I couldn't believe this was happening. You know, and it's like, okay, you're saying you feel bad for him. And then here, you're talking about him like he was waffled, like he is just a piece of meat. You know, like I couldn't believe that he used that terminology. And that's why AJ is focusing on that here. But let's keep going.
Did you answer, she waffled him, I looked at his body at the hospital?
I did answer that, yes.
And then Bird questioned, she waffled him, correct?
Yes.
And then you responded, he was banged up. Is that right?
Yes.
Then a person with the phone number 0095 wrote, I thought he was drunk. Did he get beat up? You see that?
I do.
And you wrote, nope. Is that right?
Correct.
Yet again, this is before 11 o'clock at night on January 29th, 2022, some 16 hours into your investigation. Is that right?
Yes.
So before you ever went to the crime scene, before you ever went into the house, only having interviewed 3 folks, you had this case nice and wrapped up, didn't you?
Yes, based on the evidence my office uncovered that day, the one shoe discovered at the scene, the one shoe at the hospital, Mr. O'Keefe's injuries, the broken taillight piece is underneath the snow.
Super Proctor, I didn't ask for an explanation. I asked, did you, in your mind, have
one
this
day.
case wrapped up? Was
one
it cut and
day.
dry in your mind?
Yes.
Bird then writes, so the owner of the house was a woman. Sorry, was a woman cop that beat him, question mark, right?
Yes.
And then you wrote, that's what I initially thought after talking to Canton paramedics. Is that right?
Yes.
And then you said, then I saw the guy, correct?
Correct.
So what you meant by that, Trooper Proctor, was according to you, based on your conversations, your initial conversations with the paramedics, the first responders, you were under the impression that this was a beating death. He'd been beaten to death, correct?
The way it was given to me, sir, was
That's yes
for
or
medical.
No? That's yes or no?
He's going to answer the question. If you want
Go
to
ahead.
withdraw the question, you can.
No, go ahead.
We entered this investigation with an open mind. It was given to me as a medical situation. And when we saw Mr. O'Keefe's body at the hospital with Sergeant Buchanan and I, we saw his injuries and we were kind of working through how these injuries occurred.
As a matter of fact, both you and Sergeant Buchanan believed that he had suffered the injuries as a result of a physical altercation based on information you received from the paramedics initially, correct?
Initially, we didn't know what we had. We knew there was some significant injuries to Mr.
whatever.
O'Keefe. And we're still figuring out how those injuries occurred.
He
Well,
doesn't
you
want
just
to say it.
testified. Initially, we didn't know what we had.
Right.
But 16 hours after the fact,
Yes.
you wrote the following sentence. That's what I initially thought after talking to Canton paramedics, correct?
Correct.
So initially, you did think you knew what you had. A physical altercation leading to a
Good
death.
job, AJ.
Correct?
Correct.
So when you just said, initially we didn't know what we had, that wasn't quite true. You did at least have an idea of what you thought you had, correct?
Objection.
Sustained.
All right. You were aware, initially, that John O'Keefe had suffered a 2-inch laceration to the back of his head, correct?
Yes.
That resulted in a skull fracture, correct?
Correct.
He had a laceration over his right eye, small laceration just under the eyebrow, correct?
Yes.
Had a laceration on his nose. Is that right?
Correct.
He had patterned scratches on his right arm, abrasions, scratches, correct?
Yes.
And he had no injuries below the neck.
Not that I observed, sir.
Not a single broken bone, correct?
Not that I was aware of.
Not a single fracture, correct?
Not that I was aware of.
Not a single bruise below the neck, right?
Not that I observed.
Looks a lot like a physical altercation, doesn't it?
Objection.
Sustained.
What do you guys think he's going to do for work these days? Can't be a cop anymore.
Bird writes,
Mall cop?
Bear, let's focus, correct?
Yes.
Who's Bear?
That's another nickname I have.
0095 writes, what does she waffled him mean? And then Bird writes, what's the story, correct?
Correct.
And you wrote, she hit him with her car. Is that right?
Yes.
Have you ever seen, in your experience, have you ever seen a pedestrian who was hit by a 6,000-pound car with no bruises? Ever?
The Walmart in Quincy. They're hiring.
The pedestrian strikes I've seen have been at high speeds,
Enough to
60
knock
plus.
a person out of his shoe, right?
60 plus miles per hour. So I can't recall right now off the top of my head as far as injuries in the past pedestrian strikes I've attended.
Okay. So someone, you indicated on Monday, under examination by Mr. Lally, you've seen a shoe missing.
Correct.
Pedestrian strikes, correct?
Yes.
Those are high speed, extremely high speed incidents, correct?
Yes.
60 plus miles an hour, right?
I can't recall all the
You just said 60.
pedestrian strikes I've been to as far as the miles per hour the vehicle is traveling.
Trooper Proctor, let me ask you the question again. Have you ever, yes or no, have you ever, in your experience, seen a vehicle pedestrian incident in which the pedestrian has no bruises?
Objection.
Have you seen that?
I can't recall.
Next question.
Burger King siren. But he'll probably tell his friends what you ordered.
After you wrote, she hit him with her car, 5051 writes, oh Jesus, and Bird writes, okay, that's fucked up, correct?
Correct.
And then you wrote what?
Intentional or not?
Intentional or not? Is that right?
Yes.
Your words.
Correct.
0095 then chimes in, gotcha. He was frozen in the driveway and she didn't see him? Question mark.
Frozen?
Correct?
Correct.
And you wrote what?
That's another animal we won't be able to prove.
That's another animal we won't be able to prove. Correct?
Correct.
Trooper Proctor, you knew that there were going to be things in this case, even 16 hours into this, that you just admitted you would have zero proof of, correct?
Objection.
Sustained. You can ask it differently.
Did you mean by that statement that this was one of several things that you knew we would not be able to prove?
That statement, that's another animal we won't be able to prove, references the intentional or not part.
You didn't care at that point when you wrote that, you didn't care what you could or could not prove, did you?
Objection.
I'll allow it.
Isn't that what you meant?
No.
I had a narrative that you had developed, and you would pursue it no matter what the proof was. That's what you meant by that statement, correct?
Objection.
Sustained. You can ask it differently, Mr. Chair.
Did you mean by that, thank you, Your Honor, I didn't mean to step on your words. Did you mean by that statement that you were going to pursue this case no matter what the proof might be?
What I meant by that statement was if Miss Reed backed into Mr. O'Keefe intentionally or not.
Interestingly, though, that statement came on the heels of he was frozen in the driveway and she didn't see him. And you wrote in response to that question, that's another animal we won't be able to prove. Correct?
That's not what I was responding to. I was responding to the intentional or not part.
So you were responding to your own statement.
Correct.
Okay. 0095
I was responding to my own statement.
then writes, what's the name of the Canton cop living in Canton? The other one involved. Correct?
Yes.
In other words, that person was asking, tell me the name of the homeowner. Isn't that right?
Yes.
The guy that's the cop, right?
Correct.
And you ignored that question for a second time. Is that right?
Yes.
As a matter of fact, not one time.
He's talking
not
to
once
himself.
In this entire group chat, did you disclose the name Brian Albert? Did you?
I don't believe so, no.
You were actively trying to hide Brian Albert's name, at least from this conversation.
Objection.
I'll allow it. Is that what you were trying to do?
Absolutely not.
But you had no problem sharing John O'Keefe's name with your buddies from high school, right?
Correct.
And you had no problem sharing Karen Reed's name with your buddies from high school, correct?
I don't believe I named the defendant.
Not yet, you didn't. Later in the chat.
When it turns
correct.
up.
5051 then writes, the BPD have any jurisdiction here because it was their own? Question mark. Is that right?
Yes.
And a few texts later, if you look down a few texts, at about 11 o'clock, you see a text that starts, nah, cat.
Nah, cat.
I do so, yes.
You responded, quote, nah, N-A-H, nah, cat, K-A-T-T. It's the total opposite. they have to recuse themselves. Same with Canton, correct?
That text ends as they have to recuse themselves.
You then text back, I'm sorry, can I have a moment?
Yes.
Flip the next page.
I see where you're at, sir.
How did you end that text?
Same with Canton.
Meaning Canton has to recuse itself also, correct?
That was my understanding.
So by 11 p.m. on January 29th, 2022, there was no question in your mind, Trooper Proctor, that the Canton Police Department was recused from this investigation in all particulars, correct?
That they had taken a step back from participating, yes.
Right. Well, there's one way to put it. They've taken a step back from participating. Another way to put it is they recused themselves completely, correct?
Correct.
They were not going to be, at least in your mind, they were not to be involved in any way, just like Boston PD was not to be involved in any way. Is that right?
Objection.
Is that what you were thinking?
It was my understanding they were not going to be involved.
Now, if we could turn to page 2537. (5051) writes, but I assume you guys are out to make it cut and dry since it involves cops, correct?
Yes.
And Bird writes, something stinks, correct?
Correct.
And then Trooper Proctor, you responded, yeah, but there will be some serious charges brought on the girl. Isn't that right?
That's right.
So in that text exchange, you were saying, yeah, we're out to make it cut and dry, correct?
No.
You didn't write, yeah, we're going to follow the evidence wherever it takes us. You didn't, did you?
I did not write that.
You didn't write, yeah, we're going to make sure that we investigate this thing fully and thoroughly before making any decisions. You didn't say that, did you?
I did not.
You wrote, yeah, but there will be some serious charges brought on the girl. Isn't that right?
Correct.
And the reason you wrote that is because you knew, as the text above it says, this has to be cut and dry because it involves cops, right?
Objection.
I'm going to allow that. Is that the reason you wrote it?
No, Your Honor.
And then you indicated, we're going to put serious charges on the girl. Who did you mean by the girl, by the way?
The defendant.
Karen Reed?
Yes, sir.
So the way that you were going to make it cut and dry, pretty simple. Just pin it on the girl, right?
Objection.
Is that right?
Absolutely not. Follow the facts and the evidence from that day on the 29th, and everything led to Miss Reed hitting Mr. O'Keefe with her vehicle.
But that wasn't the question that you were answering, was it? We're going to follow the evidence and make sure we do this
The defense team is like, that is such bullshit.
thoroughly. The question you were answering was, I assume you guys, you, Trooper Proctor, and your team are going to, quote, make it cut and dry since it involves cops, meaning Brian Albert, correct?
Incorrect. Doesn't matter to me if the homeowner's a cop, if the victim's a police officer. Myself and everyone in my office investigated this case that Saturday, had an overwhelming amount of evidence that Miss Reed struck Mr. O'Keefe. So it didn't matter to us what their occupation was.
We'll see. Let's keep reading, shall we? 5051, a little further down, says, gotta be. I could only imagine what internal affairs at BPD are trying to get out there. Correct?
Correct.
Meaning, this person, 5051, was opining, at least in your mind, you interpreted that as being Boston police are going to have a lot to answer for, given the fact that another Boston police officer was found dead on that officer's lawn. Correct?
Objection.
What were you thinking?
Can't speak to the mindset to that comment. I wasn't sure how to interpret that one.
All right, next question, Mr. Jackson.
Then 5051 changes gears. And he writes, she hot at least? Correct?
Yes.
And what was your response to that?
From all accounts, he didn't do a thing wrong. She's a whack job cunt.
From all accounts, he didn't do a thing wrong. She's a whack job cunt. That's what you wrote, correct?
Correct.
16 hours into this investigation.
Yes.
Into your objective and unbiased, thorough investigation, correct?
Correct.
But sir, you didn't have all accounts, did you?
What I meant by that was...
Did you or did you not have all accounts in your investigation?
The accounts we had was Miss Reed struck Mr. O'Keefe with her vehicle.
Look at how red he
Discovered
is.
taillight pieces at the scene. Those are the accounts we had.
You didn't have it on day one.
I'm sorry, go ahead.
I'm sorry, go ahead.
The accounts you had, Trooper Proctor, were from 2 people named McCabe and 1 named Albert, who happened to be the homeowner and a Boston cop. Those are the accounts from percipient witnesses that you had, correct?
There was another additional witness that we had, investigators had interviewed, Miss Roberts as well.
And from all accounts, he didn't do a thing wrong. That was your decision 16 hours into the investigation, correct?
Yes.
And the other decision that you made and the other determination you came to was my client, Karen Reed, was a whack job cunt, right?
Yes.
What else did you say in response to, she's hot at least? Or she hot at least, question mark?
So following that text, I responded, yeah, she's a babe. Weird Fall River accent, though. No ass.
Yeah, she's a babe. Who's the she?
Miss Reed.
Weird Fall River accent, though. You talking about her, the way she talks?
The accent.
And no ass. Now you're talking about her body, her physique, correct?
Yes.
You think that's appropriate?
Absolutely not.
Then Bird chimes in with a little comedy.
If this is what was on his phone, imagine the other investigations chat. Imagine.
Not newsworthy then, correct?
Correct.
In other words, well, if she didn't have an ass, nothing to see here, correct?
Objection.
Sustained.
And then 5051 says, oh, she's skating, right?
Correct.
And what did you write after that?
My response was 0 chance she skated.
And then what did you write?
She's fucked.
0 chance she skates. She's fucked, right?
Correct.
On day one.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided you're going to make sure this is cut and dried, and the way you're going to do it is to make sure that she's fucked. That's what you were saying.
Objection.
All right, so that's sustained. You can, the content's fine. You have to ask it differently.
17 hours into this investigation, Trooper Proctor, you made the decision that you were going to put it on Miss Reed, didn't you? Put the case on Miss Reed. She was going to catch the case, correct?
No, absolutely not.
What did you mean then when you said she's fucked?
After the day's investigation with multiple troopers conducting multiple tasks.
Day one.
And a debriefing at Canton PD amongst detectives in my office. We went through the overwhelming amount of evidence
On
against
day
Miss
one.
Reed that she struck Mr. O'Keefe with her vehicle.
On day one.
That's what I meant by that comment.
On day one.
What you meant by that comment, Trooper Proctor, was you were going to make sure because 5051 had said she's going to skate. She's skating. When you said 0 chance she skates, she's fucked. What you meant was I'm going to make sure, I am going to make sure Ms. Reed doesn't skate. She's fucked.
On day one.
Objection.
Sustained.
And then Bird decides to chime in. Good, no ass bitch, right?
Yes, that's what he wrote.
And how did you respond?
I always
to
forget
Bird
about that
saying,
one.
Good, no-ass bitch?
I laughed.
Thought that was funny, did you? Trooper Proctor? Thought that was funny?
It was unprofessional of me. That's something I shouldn't have done.
Well, I think we all know it was unprofessional. It was a lot of things. I'm asking you, did you think it was funny?
No, according to my response at the time, apparently.
Then you sent a picture, just to add to it.
He added a
pile
meme?
on of Miss Reed being arrested, correct?
I don't.
Oh, he sent a picture of her being arrested to your friends from high school.
I'm not sure if that came from me, sir.
Let's skip to 2543. Are you there, Trooper Proctor?
Yes.
The date is now February 2nd, 2022. And a person by the name of Doc writes, "Is that chick a smoke?" Correct?
Correct.
Who's the chick?
Miss Reed.
And you write E-H, right?
Yes.
And then you write nutbag, as Chief would say, correct?
Correct.
Who's Chief?
A friend of mine.
And then you write what?
She's got a leaky balloon knot.
Trooper Proctor, explain to the jurors what a balloon knot is.
Your essentially, I guess, your rectum area.
Your anus?
Yes.
That's what you were referring to about Miss Reed?
Yes.
And you were making fun of her because you believed at that time that it leaked? That's how you were treating Miss Reed? Yes or no?
Yes.
And then you...
Yannetti wants to punch him. Like, let's just... Yannetti wants to deck him in the face. Look at the stance. Yannetti is pissed.
Followed that up just to make sure you cleared up any mistake about what you meant with leaks poo, correct?
Objection.
All right, so I'm going to strike that. You could get this in, but do it the right way, Mr. Jackson.
You followed that up with the phrase leaks poo, didn't you?
I did.
Again, another reference to Miss Reed's medical issues and medical conditions, correct?
Correct.
Specifically focused on her anus, correct?
In reference, yes.
Were you aware at the time that you wrote this that Miss Reed had suffered a colectomy surgery, very serious surgery?
I was not, sir, no.
Were you aware that she had had
What a
10
jerk.
surgeries in 18 months, several years prior? 10.
I was not aware of that.
Were you aware that she had serious medical issues, gastrointestinal medical issues that she suffered with, she was a victim of for years? Did you know that?
Objection.
Sustained.
But you decided that you were going to take another shot at her and talk about her anatomy. 1 second, sir. I'm sorry. I'm sorry. You decided that you were going to take another shot at her and talk about her anatomy as a balloon knot, correct?
Objection.
Sustained.
At this point, Trooper Proctor, Miss Reed was just reduced to a punchline to you, wasn't she?
Objection.
Sustained.
Well, you weren't done yet. This chat doesn't end yet, does it?
No, sir.
Let's skip to 2543.
This is why he was fired.
On the same date, February 2nd, 2022, about 4:15 p.m., a person by the name of Whitey wrote, "What are you guzzling on?" Correct?
Yes.
And you wrote nothing, writing a warrant. Is that right?
Correct.
Why did you then share some sort of a video? Correct?
Yes.
You remember that video being of the 1980s band Warrant?
I don't recall the video he sent.
0095 laughed and then wrote, wait, why does her asshole leak? Correct?
Yes, that's what he wrote.
And then what did Doc write in response to that?
Objection, Your Honor.
The objection sustained. I'll see you at sidebar. Take that down, please.
So these guys were actively making fun of Karen and this group chat. 9 people that he grew up with. Like, this is why he was fired by the Massachusetts State Police. And the fact that the MSP is trying to distance themselves from him. And we read that in that article, I think it was an hour ago at this point, where I pulled up this morning's article. And when we found out, they're the ones that voted unanimously on having him continue to pursue his effort to come back to the force. After what is on those phones, or what is on that phone? He thought that he can delete his text messages every 30 days. Higgins and Albert threw their phones away. What is on that phone? This is just one.
You are unmuted.
Just one. Imagine the others.
Take that down.
Without reference to the specifics of what was...
I'm going to see counsel at sidebar.
Sure.
Hey, Jim.
I'm happy that we can skip through these. But this was Karen's first trial when Proctor spoke. First one, not the second.
Used in the following, in the next exchange that you're looking at, it's fair to say that your high school buddies then continue to discuss Ms. Reed's medical issues, correct?
Objection.
That's sustained. Come on, Mr. Jackson. That isn't what you said you'd ask. Go ahead and ask the question you said you'd ask.
No, Bev. This
Was
is
there a
third time.
continued discussion that finished on this subject matter?
Yes.
On Monday, you indicated that your conduct in this case, and specifically your conduct as reflected in these messages, how did you put it? It did not affect the integrity of the investigation, of your investigation, correct? That's what you
Correct.
said to the jurors.
Correct.
He said that.
Do you know what the definition of integrity is?
Doing the right thing when no one's looking.
Thank you, AJ.
It means the quality of being honest and having strong moral principles, correct?
Objection.
Sustained.
Do you believe that integrity means being honest and having strong moral principles?
I believe that's part of it as well.
Do you stand by that testimony that you were showing strong moral principles in this investigation, sir?
In the investigation part, absolutely. Through these text messages, absolutely not. They were juvenile and regrettable.
When you say they're juvenile and regrettable, it sounds like you're almost apologizing to the jury for your conduct. Is that what you're doing?
For those text...
Objection.
Sustained.
For the text messages.
Proctor, have you ever...
Listen to what he just said, chat. For the text messages. He is not apologizing for the way he handled the investigation. He was just about to say for the text messages. I love looking at footage like this, like a year later, because we can now pick up on the human subtleties. For the text messages. There's 2 things that you should probably apologize for, because these people have to hear the vile things you said about a woman, not a man that you're investigating, a woman. Crazy.
Apologize to Ms. Reed?
Objection.
Sustained.
As the lead investigator in this case, you were tasked with the responsibility of making sure that the investigation remained free of any conflicts of interest. That's part of your job, correct?
Correct.
Throughout the pendency of this investigation and this case, you've denied having any conflict of interest in this case. Isn't that right?
Correct.
In fact, a couple of months ago in February of 2024, you testified in a different proceeding. Is that right?
Yes.
And you testified under oath in that proceeding on February 1st that you did not know any members of the Albert family or McCabe family.
I forgot about this.
Correct?
I forgot about this part.
Certain members of the Albert family I did not know. I know Chris and Julie and Colin. I don't know the McCabes.
That wasn't my question. Did you testify? Let's take them one at a time. Did you testify under oath, same oath you took here today, in a former proceeding in February of 2024 that you did not know and did not have any relationship with members of the Albert and McCabe families? Did you?
I haven't had a chance to review those minutes. I've only had one opportunity to, and that was a couple months ago. So I would want to review those minutes in order to answer that accurately.
You can't remember how you testified, whether or not you knew or had relationships with the Alberts and McCabes?
Objection.
Sustained.
As you sit here right now, you need to refresh your recollection. You can't remember what you said?
Objection.
Loading.
Do you remember what you said?
During that proceeding, no.
Would it refresh your recollection if you took a look at those grand jury minutes?
Yes.
What page, Mr. Jackson?
This is page 01563.
For those that are coming in, Proctor has denounced or at least withdrawn his appeal to get his job back. That is as of yesterday, and we are talking about that today.
If I may have just a moment, Your Honor.
Yes.
We're looking at his footage from last year. 2 years ago at this point. Karen's first trial. The bad things he said about Karen.
Fair question.
Yes. He's very
You'd
confident
review that and look up.
he's going to get his job back. Doesn't look like it now. Debbie, I didn't know that. His attorney also withdrew as his lawyer. What? We looked at some of the last filings from Friday at the beginning of the stream, but now we're just topping it off with, this is what he said. This is why he was fired. There's no reason why you need to be talking to your friends about your work as a police officer. Hey, police.
Okay.
Would that refresh your recollection about a question and answer that you had, or a series of questions and answers that you had while you were testifying under oath in that other proceeding?
Yes, sir.
Objection. May we approach?
Yes.
So again, I just tried to fill you in, Superwoman 69. For those that are coming in the middle of the stream, Michael Proctor has withdrew his bid to get his job back. What we found out during this stream, I thought it was just voluntary, just out of nowhere, like, oh my God, they cloned my phone. No, the Massachusetts State Police, there is a governing body. They voted unanimously that they're not going to support for his bid to get his job back. That came out this morning. So yesterday's news, everybody was just shocked that this happened, but it's not because of Michael. It's because the Massachusetts State Police are not going to support him. And when they have cloned your phone, because you think that every 30 days you're just going to delete the data on your phone, it still lives in the cloud. That cloud data was recovered. There's something on it, chat. There's something on it. And it relates to the King case and the other cases that Michael Proctor has investigated. And if this is how he was treating Karen, it's very possible that the other cases that he was working on, he shared, information about his investigation. And you shouldn't be doing that. The thing is, though, I have seen body cam footage where police officers will take pictures of evidence and things at a crime scene using their personal devices, sometimes, devices that are issued by the police departments. But at the end of the day, you really should not be having personal conversations and filling your people in on what's going on. So right now we are reviewing Karen's first trial, and we're reviewing exactly what Michael Proctor said, because in the second trial, he did not testify. Many people expected him to testify. Many people thought he was going to be called. He was on the Commonwealth's list and he was on the defense list, but ultimately they decided not to call him. In August, he launched this full thing of, I'm going to get my job back. I almost like to call it a campaign to get his job back, because the day that Karen was exonerated in June, just a few months ago, I thought it was crazy that his 2020 interview on that show, 2020, it came out literally hours before Karen was exonerated. I was like, really? Can you let her have her day? Literally, that day, hours, 2-3 hours. We were all watching it all day. It's probably happened, if I remember correctly, around 2 or 3, maybe even 4 o'clock. That interview was up by 8. So Proctor had gone on this campaign for his job. You know, we saw the interview. He was a little security heavy. He was a little heavy compared to what he looks like in this footage. But he kept saying that he didn't do anything wrong, and he stands by the investigation. But remember, the series of text messages that we're talking about right here in AJ's Brillant cross, these are day one into the investigation, and these are the conclusions that he's come to. These are the things he's talking about with his friends. And it really makes you wonder, can we trust the police? I mean, so many of you guys have been following this case for years, and many other cases related to it that Proctor has investigated. Sarah Birchmore, many others, Brian Walsh. The King case has come up in some of these documents. It's so crazy. So let's continue. We have probably about like a half hour left. And, again, thank you to everybody that has sent to Super Chat. I have read most of them, and then I'll wait till the end to read any more that come in after this point. But let's get back into it.
You are unmuted.
Mayor, Your Honor?
Yes.
Thank you. You were asked the question, quote, did you communicate with First Assistant DA Brillant that you did not know and had no relationship with the Albert and McCabe families? And you answered, quote, to the best of my recollection, same conversation took place with everyone I talked to about this, because it's the same answer. It's the facts that I shared with everyone. Question, meaning you told First Assistant Brillant that you didn't know, didn't have a relationships with
Objection, Your Honor.
members of the Albert and McCabe families. Answer, correct.
Yes, that's correct.
So your question is whether he said this?
Correct. Whether that's his testimony. Do you recall that?
Yes.
And that's your testimony, that you, in fact, told members of the DA's office that you did not know and did not have a relationship with the Alberts or McCabes. Is that right?
I did not know the McCabes. I don't know most of the Alberts, and I have little to no relationship with Chris and Julie. So that's what I meant by that answer.
Well, the question wasn't, did you know most of the Alberts? The question was, did you have a relationship with, or did you know the Alberts? And your answer was, no.
No, I don't have a relationship with the Alberts.
Or know them.
I don't know the McCabes. I don't have a relationship with the Alberts.
So you do know the Alberts, correct?
I know some of them, Julie and Chris.
And Colin, correct?
Correct, and Colin.
And you knew the Alberts when you gave this testimony in February of 2024. Is that right?
Yeah, they asked if there was any relationships.
Let's try this again. Meaning you told First Assistant Brillant that you didn't know, didn't have relationships with members of the Alberts and members of the Albert and McCabe families. Answer, correct.
Mm-hmm.
Was that ambiguous in your mind?
The way I interpreted relationships was basically being like friends or,
oh my God.
Communications, frequent communications. That's how I interpreted it.
Well, that might have been a good time to pipe up and say, well, I know Chris and I know Julie and I know Colin, correct?
Objection.
Sustained.
That might have been a good time to answer the question, I know these three individuals from the Albert family, right?
Objection.
Sustained.
But your answer was one word, correct, right?
Yes.
You further testified that you never have gone to any supervisor at Massachusetts State Police to disclose even a potential conflict of interest in this case that you might have, correct?
Correct.
And you indicated the needs never come up. Is that right?
Correct.
You also told ADA Lally that you, quote, did not have relationships or know members of the Albert or McCabe families, correct?
Correct.
And that's just not true, is it? You did know, you do know members of the Albert family.
Exactly.
Isn't that right?
It's different from having a relationship with people.
But what
You know
about part of
them.
the question, did not have relationships or know members of the Albert or McCabe families? How about that part of the question?
Well, that's lumped in with the McCabes. I don't know the McCabe family, sir.
I see. So what you...
But still, it's still a lie. It's because it has both families connected. So this is so interesting. He's looking at him like, well, it's still a no because I don't know the McCabes. Okay, fine. The question wasn't separated. But let's see what AJ does here.
Did, Trooper Proctor, is you dissected the sentence, and where relationships are concerned, you ignored that in terms of the Alberts because you don't have relationships. Where no is concerned, you link that to the McCabes because you don't know the McCabes. That's what you did?
No.
That is what you
it's
did.
Sustained. You can ask it. You can break it down.
That's
Mr.
smart.
Johnson.
Not sure I can. I'll ask it a different way. How about if I just ask it this way? That was a lie, wasn't it?
No,
Thank you.
absolutely not.
You stand by that testimony?
Yes.
That you don't know at the time that you testified, that you didn't know the Alberts or any members of the Albert family?
They don't have relationships with them.
Okay. My question is, you keep going back to relationships. I'm asking you, did you testify that you didn't know them?
Objection.
I'll let him have it. Do you understand the question, Trooper?
I knew Chris, Julie, and Colin.
So if you were to say, I don't know any members of the Albert family, that would have been a lie. Correct?
Objection.
Sustained.
Your Honor, this is the point at which I intend to turn to tab 3, and I believe we need to approach.
Okay.
All right.
Jurors, feel free to stand.
We have TiVo time. I love TiVo time, guys. So we can skip through our breaks, bring us to current time. That was a very long break. Well, not a break, a sidebar. Picks up right around here. That was a super long sidebar.
Yeah, just a moment, Your Honor.
Yes.
AJ without a beard is always good to look at, too.
Sister is one of your best friends, maybe your best friend.
Yes.
Courtney Proctor, that's her name? Courtney
Correct.
Proctor. Elberg?
I'm sorry?
Her last name?
Elberg.
Elberg, with an L. And you're aware that she is also very, very good friends with Jillian Daniels, Julie Albert.
Correct.
Are you aware of any circumstance in which any of the Alberts have been over to your parents' house?
Yes.
Have you ever been over at your parents' house when any of the Alberts have been at your parents' house?
Yes.
Those Alberts include Chris Albert, Julie Albert, Colin Albert, correct?
Correct.
As a matter of fact, you were on or around January 29th, 2022, you were close enough friends with Julie Albert that she had your personal cell phone in her cell phone, correct? And vice versa.
I wouldn't classify us as close friends at all.
But you had each
Okay, let me get back to my question. Did you have her cell phone in your phone, and did she have yours?
I can't recall if I believe I had her stored in my phone.
Tab 4.
This is so bad to watch in retrospect.
All right. If you would turn to tab 4.
And what was this marked for ID?
This was...
Or tell me the numbers at the bottom.
Oh, I've got the sheet right here. I've got a cheat sheet. Tab
Scott
4
is just dropping all the tea, guys.
As in Bravo.
Watch these chats. Scott is giving us the tea.
And Your Honor,
Comes
for
to
the court,
Morrissey.
I'm looking at page 2625. You have that in front of you, sir?
Yes, sir.
Do you recognize the participants in this chat?
I do.
The number ending in 5374, you recognize that as being from Julie Albert?
Based off the content of the message, yeah, I recognize this text message from Julie.
And she texts, "This is the weekend I've been waiting for. Michael, please send ski videos if CP doesn't share with me," with a laughing face, correct?
Correct.
That text was sent on February 24th, 2022, wasn't it?
Yes.
That was less than a month after Mr. O'Keefe's death, isn't that right?
Correct.
And less than a month after you had been assigned to the investigation in which Julie Albert was a witness, correct?
Correct.
And her husband, Chris Albert, was a witness, correct?
Correct.
And her son, you knew, Colin, was involved as well, correct?
Yes.
Who is CP in that text message?
It's a nickname I have for my sister.
Courtney Proctor, correct?
Correct.
Your Honor, if I may have just a moment.
Okay.
Some time. Can we move to Proctor to tab 5, please? That's triple C as in Charlie.
Heavy breathing up there, Proctor.
Do you have that in front of you, sir?
Yes.
And this would be page 2664. If you return to that page, please.
Jamie.
Okay.
The sister came up in this. You guys don't remember this, but the sister came up.
Trooper Proctor, on January 19th, 2022, 10 days before Mr. O'Keefe's death, you were texting with your sister about whether Julie Albert might be available to babysit for your own son.
No
correct?
Relationship, huh?
Yes.
No
So in
relationship,
fact,
huh?
your relationship with the Alberts was close enough
You guys see it?
that you would consider leaving your own child in the hands of Julie Albert as a babysitter, as a caregiver for your toddler, correct?
Oh, I love AJ.
I wouldn't say close enough.
No.
I've hired babysitters that
No.
I've had out, but I
Oh,
don't know.
I forgot about this. Oh, AJ's brilliant chat. I forgot about this moment. Do you see what AJ just did? He led him into the trap. It's just like, come close to this trap. Come close to this bear trap. Trooper Proctor is like trying to dance around it. Everything's fine. I don't know them like that. I don't know the Alberts and McCabe's. Listen to what he just said. I don't know the McCabe's. Okay, but what about the Alberts? You are happy to have one of the Alberts babysit your child, but you don't know them like that? Are you kidding me? I forgot about this.
But Julie Albert was among them.
Yes, she was an option to watch my child.
And then you personally interviewed Julie Albert and Chris Albert in this case on February 10th, 2022.
Sergeant Buchanan and I did, yes.
And you didn't mention a thing about your relationship with Julie Albert, Chris Albert, or Colin Albert in any report that you ever drafted in this case, did you?
I did not.
Not one word, correct?
No, sir.
You interviewed Julie and Chris Albert at about 5:30 p.m. on the 10th of February, isn't that right?
Yes.
Did either of them, Julie or Chris Albert, mention that their son Colin Albert had been at 34 Fairview Road on the night in question, January 29th?
I'd have to reread the report to refresh my memory on their statements.
Well, let me ask it a different way, if I may have just a moment.
Yes.
I don't know them, but I asked one of them to watch my kid. Oh my God. I forgot about that. It's your kid. Your child.
You wrote a report on October 12th, 2022, correct?
For which,
Concerning your interview with,
Why don't you show it to him?
I may have the wrong report.
Come on, Liza, with the assist.
Do you recall, Trooper Proctor, ever mentioning that whether or not Julie and Chris mentioned to you that their son had been at 34 Fairview on January 29th? Do you recall that as you sit here?
to the best of my recollection, no.
It was a very short interview with Julie and Chris, was it not?
Typical length for the information they had to offer.
So you started the interview about 5:30 p.m. It must have been relatively short because you received a phone call by 6:17 from Julie Albert herself, correct?
I don't have the call detail record in front of me, but okay, yes.
Let's look at tab 6, please.
Okay, yes. Okay, impeachment loading. Okay, yes. I don't know them. I don't know the McCabe's. Chris Albert is Brian Albert's brother. Julie Albert, Chris Albert, Julie Albert, I believe they're married. They have Colin Albert. And you guys know I did a super cut of Colin Albert from trial 1 saying, I don't remember, like probably over 100 times. I don't remember. I don't recall. I don't know. I don't know. I don't remember. I don't recall. That was like his answer to every question. And then we, learned about some of his different videos where he says, pull up B, some of those other videos. We learned a lot about Colin Albert. So Chris Albert, Julie being able to watch your children. Let's watch this impeachment happen in real time. Well, not real time, but you know what I mean. Let's see how AJ handles this.
It may not be in your book.
It's not, sir.
Okay, fair enough.
I wonder if he knew that he was about to lose his job.
You indicated that you might need to look at a phone record or a phone log to determine whether or not that call was made and what time it was made, correct?
If you have that,
May
please.
I approach you on it?
Yes.
Thank you.
There's a highlighted portion, Trooper Proctor. Just focus your attention on that and let me know if that refreshes your recollection.
It does, sir. Thank you.
May I approach?
Yes.
After your interview, you received a phone call from Julie Albert about 6:17, about 45 minutes after you began the interview and then left, correct?
Yes.
6:21, you called her back and you spoke for 3 minutes and 58 seconds. Is that right?
Yes.
Did you discuss the interview?
I don't recall the content of that conversation.
And of course, you never memorialized that in any report, did you? The fact that you had a subsequent phone call with Julie Albert on your personal cell phone.
I did not.
Let's turn to tab 5 one more time. And if you could turn to page 2677. Trooper Proctor, after your interview with Julie Albert, your sister, Courtney, texted you, "How did it go at Julie's? She was so nervous." You recall that?
Yes.
In fact, you responded to that with a ha, 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 ha. 4 ha's, right? And then why, question mark, correct?
Correct.
Then you responded, "It was fine, just a quick convo," correct?
Yes.
You were literally reporting back to your sister about the progress of your investigation in a homicide investigation, weren't you?
Objection.
Sustained. You can ask it differently.
Were you reporting your progress to your sister about your investigation?
Objection.
Sustained.
Your Honor, may we approach?
Okay.
So it's not only the friends. Now his sister is inquiring, and it seems like the sister was curious about how it went with the Alberts. So his sister is now getting information about the investigation too. That's now 10 people, Proctor. 10. Karen looking fierce as ever there. We're going to skip through it. Back from this sidebar.
May I? Yes. Thank you. Were you reporting your progress of your investigation back to your sister, Courtney Proctor?
No, absolutely not.
But you did say...
yes, you were.
That the conversation, the formal interview went fine. It was just a quick convo, correct?
In response to my sister indicating Julie was nervous, that's why I told her it was fine.
Trooper Proctor, Julie and Chris Albert were not actually treated like witnesses in a murder investigation. They were treated more like friends. Wouldn't you agree?
Objection.
Is that true?
Absolutely not.
Miss Karen's faces from the first trial.
We've established that you're very close with your sister, Courtney, correct?
Correct.
You provided your sister with updates on important advancements during the course of your investigation into this case. Did you not periodically?
I made her aware of newsworthy stuff.
That started as early as January 29th, 2022. Isn't that right?
Wow, the day of.
Don't have the exact
of.
date or content.
Well, the day of the incident. You began letting her know that you were involved, that you had been
That's
assigned, what
early.
the status was,
Yes.
the nature of the case, the fact
Correct.
that it was a homicide, correct?
Yes.
This is why the Massachusetts
Matter of
State
fact, you
Police
discussed who the
doesn't
players were,
trust
who
him.
the people were that were involved. Isn't that right?
I just mentioned Julie and Chris were out earlier in the evening.
Guys, like, here's the thing. It'd be one thing if it's the group chat's already insane because there's 9 people that they're not law enforcement. There should be no reason why you're keeping them updated on this case. But now we learn that you're also keeping your sister updated on this case. And she's asking questions because she knows one of the people that were interviewed. Okay, fine. But this is the 10th person during this cross-examination that we've identified that you have given information to on day 1 of the investigation. That group text with the guys, the friends that he had, that took place around like throughout the day, but a majority of the text that AJ walked through was at 10 p.m. I'm curious about the timestamp on Courtney and when they were talking through it, because if Julie Albert and Chris Albert were interviewed, that would have been earlier in the day. But this is 10 people. So now we can understand why the Massachusetts State Police unanimously said, hey, we can't support Proctor. He is very, very confident that he was going to get his job back. But with this withdrawal from this past Friday, now looking at this, we can get a little bit of some of the clues and some of the things that came up during this testimony that were problematic. Let's keep going.
So you mentioned the Alberts, correct?
Julie and Chris, yes.
You also mentioned the McCabe's too, didn't you? At some point.
Yes.
Yeah. At 2668, Your Honor, that's the page that I'm referring to. You don't, Craig, we don't need insurance at this point. You write homicide, correct?
So I said 2668.
Correct. If I have my page number correct.
You're on the right page, Mr. Jackson.
Thank you.
Okay, go ahead, sir.
You wrote the word homicide. Is that right?
Yes.
You were describing to your sister the nature of the case that you are now assigned. Is that right?
Correct.
She wrote the Canton thing is a homicide, and you wrote don't say a word to anyone. Correct?
Correct.
And then she wrote of course not. Isn't that right?
Yes.
And then you wrote what?
In the very least, it's suspicious.
In the very least, it's suspicious. Correct?
Correct.
So at that time, at least at the time that you wrote that text on the 29th at 3:05 in the afternoon, you believed that the case was suspicious, right?
It was before we found significant pieces of evidence.
So you believed that it was suspicious that it may involve the Alberts, right?
Absolutely not.
She then writes, this is your livelihood, didn't she?
She did.
Meaning this kind of case could make or it could break your career, right?
Objection.
Sustained.
She then wrote, I would never mess with that. Is that right?
Yes.
Your sister, Trooper Proctor, was warning you that you shouldn't be investigating a case in which close friends or family members were involved.
Objection.
Did you take her text? This is your livelihood. I would never mess with that, as a warning from her that you shouldn't be investigating a case that involved close friends.
Objection.
I'll allow it.
Absolutely not. That was in response to don't say a word to anyone. And that was how I interpreted this is your livelihood. I would never mess with that.
A couple of minutes later, 3:07 on January 29th, you told your sister, quote, Julie and Chris were at the bar with the victim and girlfriend. Got to interview them. Is that right?
Yes.
So you were telling Courtney, your sister, updates on what your investigation advancements were, correct?
Just that part.
Interview, why you're going to interview him.
Yes.
She wrote, you got to be kidding me.
He
correct?
admits it.
Correct.
Did you take that as you got to be kidding me? The Alberts are involved?
No, absolutely not.
And then you wrote, it's not a big deal, correct?
Correct.
And then she wrote, I bet I know the person. Sounds like it is, meaning it is a big deal, right?
Yeah, I'm not sure what she meant with those messages there.
But she did write, I bet I know the person, didn't she?
She did write that, yes.
And you know she's very close with the Alberts, correct?
And she's close with Julie and Chris.
You then wrote, no, I meant, or you wrote not. I think you meant no. I meant that they were at the bar with him, correct?
Yes.
She writes, yeah, I got that part. And then she continues on, but I know a lot of their friends, correct?
Yes.
Did you see a problem in this exchange?
Nothing jumped out at me.
Your sister's literally explaining that your family friends are suspects or possible suspects in a murder investigation that you're in charge of. Correct?
Objection.
Look at how red he gets. Look at that.
On January 30th, 2022 at 9:13 in the morning, your sister texted you again, quote, Jesus Christ. The party was at one of the Alberts.
Oh!
Correct?
I like the sister.
And you two were discussing the fact that, to put it in her words, Jesus Christ, these are our friends, right?
Objection.
How did you take her Jesus Christ? The party was at one of the Alberts with 2 exclamation points. How did you take that?
That's
Scrambling and scraping. Stuttering.
the way I'm interpreting my sister's text messages was that surprised and shocked that this is where Mr. O'Keefe was found on the front lawn of that residence.
Could it be, Jesus Christ, we know these people?
Boom.
Again, that's how I read that message.
Boom.
You don't deny, Trooper Proctor, that you were routinely disclosing to your sister pretty intimate details about the investigation, correct?
I wouldn't say intimate. I'd say newsworthy stuff or just generic, nothing too specific.
Newsworthy, would you have gone to the news at this point in the investigation? Would you have gone to the news and said, Julie and Chris were at the bar, I got to go interview them?
Objection.
I'll allow that. Is that what you do, Trooper?
No, I would not do that, sir.
So it was not newsworthy. These were details, internal details about the investigation, weren't they?
Yes.
And you were sharing them with your sister, Courtney Proctor, correct?
Correct.
And Courtney Proctor's best friend is Jillian Daniels, and one of her closest friends is Julie Albert, right?
Correct.
Wow.
Then on February 1st, 2022, your sister texts you that she's actually meeting with Julie Albert, didn't she?
Wow.
Yes.
And that was before you ever interviewed Julie, correct?
Yes.
Wow.
So it appears that Courtney was providing information to Julie of some sort before you were able to actually interview her. Is that right?
No.
Sustained.
She was, well, let me ask it this way. You don't deny that Courtney was meeting with Julie before you interviewed her, correct?
Correct.
And you don't deny that you had been providing information about the case with Courtney before you interviewed Julie, correct?
Provided information that Julie and Chris were at the waterfall and I needed to interview them. Yes, that's the information I shared.
And who knows what you shared verbally, not in text messages, correct?
Objection.
Did you, we have text messages, Trooper Proctor. Did you share other information on phone calls with Courtney?
No.
So the only information we're to believe, you talk to her 5 to 6 times a day, the only information that you claim you shared with Courtney about the details of the investigation are contained in these texts, which we have.
Objection.
I'll let you answer that. Can you answer that?
The information that I share with my sister contained within these texts, yes.
You never discussed
He's
this
lying.
case
You could see it.
verbally, over the phone or in person with Courtney.
On the phone, I'm sure there's been conversations that's things that have been newsworthy items that have gone
He's lying.
to the news.
This
There's definitely been conversations in that regard.
Chat, listen, we're going back. Can you hear the lies and how he's trying to scramble and scrape up in his mind an explanation of why he did that? That is why the Massachusetts State Police does not trust him. And he just admitted to it because AJ's asking him. He's just like, I'm going to pin you down here. Are you literally telling us that when it comes to your sister, you gave her no other information about this case before she met with the Alberts, before they met with you? Are you literally going to tell us that? And he's like, I think on the phone, I might have said something, but it's only newsworthy stuff. Here's the thing about the phone conversations. We can't extract that from your phone, at least right now. Wiretap laws, things of the like. But if they're able to pull those calls, just like in the Donna Adelson case, like there were wiretaps. I don't know if that's happening here, but I think he knows that the text messages are memorialized because it's your words. We can see it. We can read it. When you're on the phone, we can just see the duration of the call, not the content of the call unless we have a recording. But you can see him get very nervous right here. I do want to rewind a few seconds because you can see him get very, very nervous right here. I wasn't expecting that. And this is why I do like to go back in time and look at things that are relevant to today's news, knowing that he is no longer petitioning to get his job back, that he does not have the support of the Massachusetts State Police to get his job back. I do think it has to do with this testimony right here. Let's go back a few seconds and see that scrambling and scraping in an act.
Providing information about the case with Courtney before you interviewed Julie, correct?
Provided information that Julie and Chris were at the waterfall and I needed to interview them. Yes, that's the information I shared.
And Who knows what you shared verbally, not in text messages, correct?
Objection.
Did you, we have text messages, Trooper Proctor. Did you share other information on phone calls with Courtney?
No.
So the only information we're to believe, you talk to her 5 to 6 times a day. The only information that you claim you shared with Courtney
he said no.
About the details of the investigation are contained in these texts, which we have.
Objection.
I'll let you answer that. Can you answer that?
The information that I share with my sister contained within these texts, yes.
You never discussed this case verbally, over the phone or in person with Courtney.
On the phone, I'm sure there's been conversations.
He just changed his answer. AJ asked him very clearly, have you discussed this case with your sister on the phone? Other than what's been shared on this text. He said no. Then AJ asked him, have you talked about this case at all with your sister on the phone? He says yes. He's going to try to contain it to newsworthy things. They absolutely talked on the phone, especially if you talk 5-6 times a day. Dude, you're working. Shouldn't you be going and investigating things and being a state trooper? Why are you talking on the phone with your sister that many times during a work day? Is interesting too, but let's keep going.
That's things that have been newsworthy items that have gone to the news. There's definitely been conversations in that regard.
And scraping.
Then before you ever interviewed Julie, your sister informed you that Julie actually wanted to get you a gift for your participation on this case, correct?
Yes.
In tab 5, let's turn to page 2672, Trooper Proctor. With court's permission, may we publish?
Yes.
Back page 2672. You see the text from you, what's up?
Yes.
Oh, Lord.
And what's Courtney Proctor's response?
Nothing. I just saw Julie, and she said when this is all over, she wants to get you a thank you gift. And I respond with, get Elizabeth one.
Hang on just a second. Let's take them one at a time. You were asked about this on direct examination by Mr. Lally, right?
Correct.
And you looked at the jurors, paused, and said, I never asked for a gift. I never asked for a gift.
You just asked for one right there.
Correct.
You said you never asked for a gift, correct?
Correct.
What's your next text?
Hold on.
Get Elizabeth one.
That's
Get Elizabeth
asking.
one what?
Referring to a gift.
Right. So you did, in fact, ask for a gift, didn't you?
For my wife who had been home with my children for the last 10 nights.
From Julie Albert.
Yes.
For your participation on this case.
I don't know if that's yes.
Well, Courtney Proctor answers that question by saying, because I guess her and Chris were friends and John, and she's so proud of you for leading this investigation.
The
correct?
lead investigator.
Correct.
You're aware during the course of your investigation, well, let me ask it this way. Let me ask a foundational question. Do you pull phone records as a matter of course in investigations of this nature?
Yes.
Did you pull phone records in this case, variously?
The phone records of
anybody, witnesses, suspects,
not witnesses, Mr.
people, whatever.
We didn't pull full phone records of witnesses.
Victim
and Miss Reed.
During the course of your investigation, did you become aware that there were 67 calls between Julie Albert and your sister, Courtney, in the months following John O'Keefe's death?
Objection.
I'm going to sustain that objection.
Did you become aware during the course of your investigation of the level of communication between Julie Albert, one of the witnesses on the case, and your sister?
Objection.
I'm sustaining that objection. You can come try and convince me otherwise if you want, Mr. Jackson.
I can ask it a different way, Your Honor. Thank you. Did you ever seek information about phone calls and communications that Julie Albert may or may not have been having with anybody else?
No.
Didn't download her phone, didn't seek her phone records?
No.
Did Courtney ever tell you that she had consistent communications with Julie Albert? Or did you know that otherwise?
Objection.
During the months, let me ask it this way, during the months following John O'Keefe's death, you did continue to have consistent communications with Courtney, though, didn't you?
Yes, I speak to my sister every day.
Trooper Proctor, were you using Courtney, your sister, as an intermediary between you and Julie Albert?
Big question here.
Absolutely not.
You were well aware from the very beginning of your investigation that Colin Albert was, in fact, at 34 Fairview on the night in question, right?
Yes.
Matter of fact, you testified at the grand jury, the state court grand jury on this case, that you knew that Colin Albert was at the location, right?
Yes.
Did you make any concerted efforts to keep Colin Albert's name out of this investigation?
No.
Why is it, Trooper Proctor, that Colin Albert's name fails to appear in a single police report until July 18, 2023?
Colin Albert was not at the home. He left at approximately 12:10 a.m. before anyone from the waterfall had arrived back there.
Let's look at, obviously, part of the job of an investigator is to be as complete and thorough as possible, correct?
Yes.
You don't just take someone's word for something. You look for corroborating evidence, don't you?
Yes.
Matter of fact, you wouldn't take a witness's word for almost anything in a reasonable investigation, would you?
Objection.
Would you? No,
If-
you can have that.
If I find that witness to be credible and have no reason to lie, then yes, I would take their word.
Would you try to support a witness's statement, or witnesses with an apostrophe, S apostrophe, their statements with corroborating evidence?
Yeah, potentially.
That corroborating evidence might be talking to other witnesses, right?
Yes.
It might be looking at cell phone data, correct?
Correct.
It might be looking at geolocation data, correct?
Yes.
You're trying to find out where someone is. You might pull information from their phone concerning geolocation data, right?
Yes.
You might pull cell tower information, right?
If there's a need for it.
There's myriad ways that you can find out whether someone's telling the truth about where they were and when they were there, right?
Right.
Let's take a look at your handwritten notes from your interview with Juliana Nagel on October 5th, 2022.
Julie Nagel.
This should be tab 7, Trooper Proctor. Oh,
What is it for identification?
my mistake. I thought it was in the tab. It's not. This is a 3-page document. I'll just refresh his recollection with this.
Okay, show Mr. Lally and then go ahead.
Of course. Let me ask a foundational question, Trooper Proctor. Do you remember exactly what's in your notes from a conversation that you had on October 5th, 2022?
I don't know.
Do you think it would refresh your recollection to take a look at your handwritten notes?
Yes, sir.
Thank you. Take a look at that. And first, let me just ask you if that refreshes your recollection.
It does, sir.
Are those your notes, your handwritten notes from this, at least from partially from this investigation?
Yes.
Does that reflect your handwritten notes based on a conversation that you had with Juliana Nagel on or about October 5th, 2022?
We'll wait.
Mayor, Your Honor.
Yes.
Took him 32
An
seconds.
accurate representation or an accurate copy of your notes from your interview with Juliana Nagel?
Yes.
Your Honor, with the court's permission, I changed my mind. I would like to have this marked as next.
Introduced into evidence?
Correct.
Is there an objection?
Yes, Your Honor.
And the objection sustained.
Is it true that in your handwritten notes, you list the following individuals based on Juliana Nagel's conversation with you as being at 34 Fairview? Brian, Juliana, Mary Kent, Emily Fabiano, Courtney Alba, Colin Albert, and Sarah Levinson. Correct?
Correct.
You then drafted a report memorializing your conversation with Juliana Nagel, correct?
Yes.
And that report is a formal memorialization of your interview based on your investigation, correct?
Yes, a summary of the conversation with the interview.
And that report is the thing that's turned over to the Commonwealth, correct?
Yes.
And the report is the thing that's entered into discovery and provided to the defense?
Correct.
And isn't it true that in that report, you list the individuals that were at 34 Fairview as Brian, Mary Kent, Emily Fabiano, Sarah Levinson? Is that correct?
Yes.
What's the one name that was left out of your report on that list?
Objection.
I'll allow it. Was there one name left out? Break that down, Mr. Jackson.
Sure. Isn't it true that in your report, you excluded the one name, Colin Albert, from the list of individuals that were in your notes?
There it is.
Yes, because he arrived later in the evening. The other females were there from the start.
At the time that you wrote your report, the formal report, this one, you did not believe that your handwritten notes were also going to be disclosed, did you?
No, I knew that was a possibility.
When you finally did get around to interviewing Colin Albert, you personally conducted that interview, did you not?
Yes.
Colin
Along
Albert
with Trooper
told
Zach
you-
Clark.
One at a time.
I'm sorry.
Finish your answer, Trooper.
Please go ahead.
Yes, along with Trooper Zach Clark in my office.
Colin Albert told you that he was picked up by Allie McCabe from his uncle's house at 12:10 a.m., correct?
Correct.
Allie McCabe also told you that she picked up Colin Albert at 34 Fairview at 12:10 a.m. and then dropped him off at his house, correct?
Correct.
And then she indicated that she went straight home after that, right?
Yes.
Did you conduct any further investigation to determine whether Colin Albert and Allie McCabe were actually telling the truth about that time?
We did not.
You just took them at their word, correct?
Yes.
Trooper Proctor, you realize you had a forensic image at the time. You had a forensic image of Jennifer McCabe's cell phone in your possession, right?
Correct.
You're also aware that she has a Life 360 app on her phone that tracks the location of Allie McCabe, correct?
I was not aware the app tracked her daughter. I knew of the Life 360 app, but I wasn't aware of the capability of tracking her daughter.
Did you bother to look at Jennifer McCabe's Life 360 app to determine whether Colin Albert and Allie McCabe were telling the truth about the time that they supposedly left 34 Fairview?
Objection.
Did you do that or allow it?
I did not.
Can we take a look at tab 8?
Kill him, AJ. Well, not kill him, but get it.
Do you recall looking at all at a Life 360 app or its data from Celebrate Report?
Objection.
Sustained.
Did you or did you not look at any data from Life 360 from Jennifer McCabe's phone?
Objection.
All right, so this is a good time to take the morning recess, and I'll see how.
All right, sorry guys. It appears that we are yet again having another glitch with StreamYard. This is exactly why I want to leave. Whenever I would pull up a comment like this, it would just like take the screen off and stop what we're looking at. So anyway, there were a lot of inconsistencies towards the end of that testimony, and AJ wasn't done. I think what we'll do is we will pick it up from another point, because I do think that there are some more details on the Karen Reed case that are coming out very soon. We still need the judge's decision on the civil trial, and we can pick it up from Proctor from there. That being said, I am going to get out of here. It was amazing spending time with you guys. Thank you to everyone who dropped a super chat. I do want to pick up this one. And again, look at StreamYard. It takes me off the screen when I pull up a comment like this. Okay, that works. Thank you, Scott, for all the intel today, too. He says, I certainly don't miss Bev's squeaky chair and the spinning of her eyeglasses. Never mind her size and tasks. Yes. But even with Superchats are super important to me and my community. And when I can't pull them up, I don't like that. Kelly Kell drops a 10 and says, this was the one cross I liked Bev. I think she had fun with Proctor. Speak up. She did tell him to speak up many times. But the most important thing that I would love for you guys to see from this investigation and this replay of him on cross-examination is the number of lies that were picked up. Many of you guys in the chat picked up on them, but at the same time, think about the defense team. Karen made those faces like, okay, we have you caught in some of those inconsistencies many times. And we even watched AJ pull out an answer, find that the answer was not correct, walk him through why it wasn't correct, and have him correct the answer. I think he was impeached a few times during that cross-examination. That was just part one. So we have quite a bit to catch up on. Really want to thank you guys for tuning in today. I am going to be doing Karen Reed's civil trial, just her civil trial, because again, it's a Boston native. It was very important for me to cover this one. We are going to be looking at Little Dirk tomorrow. That's going to be a standalone video. Courtney Clenny on Thursday. I want to dive into some of the investigative footage that we have of her, some of her answers, because her trial is quickly approaching on December 1st. Tomorrow there is a hearing on Relly and Rocky, but it's not going to be televised, but we do have a trial date of January 12th for Relly and Rocky. And then we'll see what happens with Karen. It could be March. If not, it could be pushed out a year. So I have my eyes on that one as well. Fake news about Diddy. Diddy is not getting out on Friday. The Trump administration said that they are not. Here's the thing. You can shorten a sentence or you can fully pardon a sentence. People have been saying that Diddy is going to get a full pardon. We have learned from the White House that that is fake news. And then if Diddy is going to get a shortened sentence from Trump is unclear. So we're doing Courtney Clenny on Thursday, and then Friday, I think I'm going to jump in and give you an update on Letitia James and everything with Fani Willis, because Fani has a hearing on November 17th. That's all I've got from my notebook. But again, we are going to be transitioning to eCam just because of, like, I don't like this. Like, I want to be able to talk to you guys, and you can see StreamYard is not allowing me to do that right now. I want to be able to read Scott's comment with me on the screen. So I like to be fully transparent with you guys. I'll keep you posted on the AV app for all of your trial watching needs. I know Emily D. Baker has one, so I'm really excited that we will have a trial watching app for all of my viewers. We do the fun stuff, t-shirt giveaways, we donate to important causes for us. We donated to Karen Reed's case. There was another creator I wanted to support, but there's all interesting stuff going on there. With that being said, I am going to let you guys go for the afternoon. I will see you in the next one. Make sure you check out some of the other recent videos that we've done. I have done a Karen Reed compilation with all the people that she intends to bring into this lawsuit and some of their key pieces of testimony. So make sure you watch that one after this. If you're into binge watching for the day, hope you guys all have a great afternoon. Stay safe out there. See you in the next one. Bye.